All persons have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. To my right and your left is Justice Amy Blake. To my left and your right is Justice Vicki Henry. We will be the panel hearing all 5 cases that are on the hearing list this morning. That is right, 5 cases instead of the usual 6. We had to postpone the argument in what previously had been scheduled as the third of our criminal cases. The first 2 cases are criminal matters. We will hear 3 cases progressing over to the civil portion of our list. And then we will take a brief recess of about 15 minutes and resume with the remaining 2 civil cases on our hearing list this morning. Those of you who have been here before know the drill, but just to repeat the bidding, we are familiar with the arguments that you've made in your briefs, with the procedural history, the factual background. You needn't repeat all of that. We have that, and we will have questions for you as you progress through your argument. Each side of the V has 15 minutes to argue. If there's more than one attorney arguing on either side, please let us know ahead of time how you'll be dividing your time, and there is no rebuttal. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains. If you reach the end of your argument before you reach the end of your time, there's no need for you to continue speaking to us. I want to extend a welcome to our visiting law students from Boston University Law School. And I wasn't going to say anything about this, but I also want to wish my colleague Amy Blake a happy 29th birthday. Is that right? 28. So with that, we will call the first case on our list for hearing, case number 2022, P920, the Commonwealth versus Jason M. Denison.
Good morning, Your Honors. My name is Rob Kidd. I'm a prosecutor at the Bristol County DA's office. I represent the Commonwealth in this Commonwealth appeal from the allowance of a motion to suppress in the District Court in New Bedford. I want to start by saying that we believe that the judge in this case was far off the mark in his decision, with all due respect to him, in calling the officer's many observations simply a hunch, which is what he said in his opinion, allowing the motion. These observations were numerous and of suspicious activity and amounted to much more than a hunch, and we contend they amounted to probable cause. We start with an officer, a detective, who's a 25-year veteran of the police department. He's made hundreds of drug arrests. He has completed scores of trainings in drug interdiction.
But counsel, I'm going to interrupt you there. There was no testimony, am I correct, as to the amount of marijuana that was found in the white Mazda?
No, there was not.
Okay. And there was no description of the packaging of that marijuana either, right?
Oh, there was not.
Okay. And you argue, I think, in your brief that gifting marijuana to somebody would be a crime under Massachusetts law, except that the law says you can transfer under 1 ounce. So how does that not cover a gift?
Well, I would point to Commonwealth versus Cotto. It's a 2015 case, and that specifically says a defendant may be criminally charged with possession with intent to distribute marijuana in violation of 94C 32A.
Wasn't that prior to the change in the law?
Well, it refers to the 1 ounce, so it refers to the 1 ounce of marijuana or less. So I believe, well, I'm not sure, but I assume because it talks about the 1 ounce that it is after the law.
If the statute says that you can transfer up to 1 ounce,
as a gift. And my second...
That could be a gift, then.
No, it cannot, and that's my second point, respectfully, Your Honor. It was not a gift. Nothing in this...
No, I know. Well, I'm just concerned because your brief does 2 things. It says that a gift can't be protected under the statute, but the statute says a transfer is permitted. I don't know what a transfer would be if it didn't include...
Okay, I'd have to look at the page. I think I said that it's not legal to it's not legal to distribute controlled substances. And yes, there is an exception in the statute for gifting the marijuana to somebody, yes.
Okay, and the other concern I had, one could argue maybe our cases don't draw a clear line, but you don't cite to us any cases that go the other way either. So, you cited a handful of cases that support your position, but there are cases that support the defendant's position as well, and we don't hear from you about those. So that leaves me with a concern here.
Well, these are highly, as Your Honor knows, these are highly fact-specific cases. So it's hard to find a case where I can point to the court. Well, I'm never going to find a case on point with the similar facts as these. It's not, I mean, it's just not going to happen. So all I can do is analogize to the cases that I found. There are a number of cases that tell us explicitly that the officer does not need to observe an actual exchange. He does not have to see what is exchanged. But those are fact-specific, and it depends on the circumstances.
So what's your best case? And that's, if I were going to pick our most frequently asked question here at the appeals court, since we have our law students here.
Yes, yes.
It is, what is your best case for that, counsel?
I would have to say I referred to it on page 14 of my brief, Commonwealth versus Stewart. It's a 2014 case. Stewart, I contest that it was a case with much less compelling facts than we have here. In Stewart, the police saw the defendant, who they knew had been arrested before for distributing narcotics. He goes down a narrow street that's known for drug dealing. They see this huddle, and there's these people counting, someone's on the way there, someone's counting money on the way, one of the persons, and then the defendant leaves. He's not the person counting the money. And the court said that that was certainly reasonable suspicion for the police to approach. We have much more here. We have a Congo line, if you will, of 3 cars going around the block 3 times. We have the defendant approaching one of those cars, reaching into the car, some sort of exchange. We have the defendant going to his trunk, twisting a plastic bag, and we know that there's case law that says that twisting bags, narcotics are often packaged in twisted bags. He puts that in his chest pocket inferentially. The officer doesn't see it, but there's a bulge. He goes back into the car. There's the classic ride to nowhere in which he's sitting in the car, and that he's driven like a block around the block. I challenge the court to find a case that has that many specific facts together that does not.
Were there prior offenses of drug distribution involving this? Were there prior offenses involving drug distribution?
No evidence of that, no.
No, okay.
So that would be a
So that would distinguish this case from Stewart?
Yes.
Okay, and was the area one that was known for drug distribution?
No.
Okay. There were no visual observations of marijuana until the Mazda was stopped, and that was not communicated to the officers before they confronted the defendant. Is that correct?
The record is hazy on that. We don't really know, so I guess that goes to the defendant.
So what you've got is the defendant going into the trunk, taking something out, putting it in his pocket, and several cars driving around in circles without an apparent destination.
No. What you have is a defendant going to his car, reaching into the car, reaching into a larger plastic bag, pulling out a smaller plastic bag, twisting that plastic bag, reaching towards his chest, then walking to the white Mazda that had just pulled over after pulling around the block 3 times, getting in the white Mazda. And then you have what we say is the classic ride to nowhere, where we say that the transaction was consummated. It's inferential that the money was exchanged to the defendant during the first encounter, right? The defendant goes over, reaches in, he gets the money, goes back to his car, twists the plastic bag.
I don't remember evidence of an exchange of currency.
No, there wasn't.
So you're talking about money, but we don't have money.
Right, I said inferential, that's what I was.
And we've got, we don't have information about quantity to get us above the 1 ounce.
No.
Well, but we do have, as to this question of gift, $3,000 on the defendant, right?
Yes.
Is that consistent with a gift?
No.
But that was discovered after the defendant was stopped, right?
Right, but let me just ask a hypothetical question. If I was going to gift somebody marijuana, would I do this? Or would anybody? I shouldn't say me. Is this consistent? Is this consistent with a gift? I mean, who does that? If you're going to give somebody, a friend, a bag of marijuana, you just give them the bag of marijuana. You don't go to your car. You don't do this kabuki dance with riding around the block 3 times, going to your car, pulling out a plastic bag, twisting it, and then going back in. What is there to hide? you would just go over, hand over the bag, and that would be it. And the other thing is, and I think it's also adds to the suspicion, Your Honor, that when the train of cars first pulls over, he first goes over to the white Mazda that's in the front of the train, right? The defendant gets out of his car, he's in the front, and then the white Mazda's behind. He gets out of his car, goes to the white Mazda, there's the reaching into the white Mazda, and then the defendant turns to the next car in line and says, you wait a minute. I mean, it's very, very consistent with the defendant engaging in multiple drug transactions. I suggest that is the next customer in the line in the cars. And again, we need to also respectfully consider. I don't think I need to say that word. I think there was a seminar yesterday that said we don't have to say that word. But I was just going to say that the evidence is not consistent with a gift. It is not. It is not consistent with gifting somebody a small amount of marijuana. It's not like a case where kids are passing around a marijuana joint. We're going to say, oh, they were all, we can't charge them with distribution. So we contend that the judge got it wrong below, that he was significantly off the mark in calling this a hunch. We contend that there was probable cause to search to the defendant even without the marijuana found in the vehicle. We contend that there was probable cause to search the defendant. And the case law clearly says—
At what point?
After the defendant got out of the vehicle. That is the point. After he went on the ride to nowhere, or the meaningless ride, as we contend, and he got out of the vehicle, that's when all those observations culminated. The twisting of the bag, which we know twists are often used to package
So
narcotics.
we're a little hampered here because there were not really factual findings from the motion judge. Is there a point at which you agree that the defendant was arrested or under arrest?
Yeah, well, I would have to say, I would agree that when he was handcuffed, he was arrested, but I think that is a red herring because that's a separate issue from whether there was probable cause to search his person.
Well, it's probable cause is probable cause, right? If they had probable cause to search, they also had probable cause to arrest, right?
Yes.
So it's your contention that on the basis of the suspicious activity and the visual observations, none of which showed an observation of either marijuana or an exchange of currency, that the defendant could properly have been placed under arrest.
Can you repeat the question? I'm sorry, Your Honor.
I'm sorry, I was sitting away from the microphone. You contend that based on the observations of the officers of the suspicious activity, that it was appropriate to place the defendant under arrest.
And search him, yes. Yes, yes.
So the timing is unclear to me. The white Mazda is stopped and also the defendant is stopped. And I'm sort of unclear whether the police knew about the marijuana in the white Mazda at the time that the defendant was stopped and or searched.
I think that's a valid concern.
We don't know.
Maybe counsel will have a different position. I'm not sure that the record is clear on that. But I don't think it matters. So, no.
All right. Well, at some point, let's assume for the moment that the police realize that what's in the white Mazda is under 1 ounce of marijuana. Does that come into our calculation at all?
Only if there was a gift, and the evidence is by no means is far from consistent with gifting marijuana. This is distribution of marijuana. It's still a crime. It's not. It doesn't fall under that part of the statute that says you can gift. You still can't sell marijuana. That's why there's a whole statutory scheme saying that only regulated shops can sell marijuana. I can't go on the street and sell marijuana right now, or whatever. I don't know why I keep referring to myself, but I'm just saying.
So he's going to get up here in a minute, and let's just say, for example, that I might have created a spreadsheet where I say the defendant is known to have sold drugs, as in Stewart, or wasn't known to have sold drugs. The areas, then there's another column, areas, high crime, not high crime. Then there's another column that the police see actual money exchange, or the police just see a touching of hands, but they don't see what was, and I go through all that. So she's going to get up in a minute, and she's going to say, well, there are lots of cases that say defendant's not known, not a high crime area, police don't actually see what was exchanged. That is definitely a dismissal.
Show me a case where there's a defendant going and retrieving a bag and twisting it, after this ride around the block, going into the car, and then a ride around the block just once, and the defendant getting out. Why are you riding around the block one time and getting out? After that activity, this is a very highly fact-specific cases. So yes, I did point out a lot of cases where there's just an exchange and no observation. Yes, a lot of those have defendants with drug histories or drug area or whatever. But we have much more here. It's much more significant what this 25-year veteran sees, and through his training and experience, he calls it a ride to nowhere. He's seen this before. The court really needs to take that into consideration in evaluating this. I think we know that this is the silent movie line of cases from Commonwealth versus Kennedy. Yes, counsel will undoubtedly ably cite the cases that talk about exchanges and distinguish them from the cases that I cite. I couldn't find a case that talks about this guy twisting a bag as if packaging narcotics. The other thing is we have expert testimony from the police officer, which is very important, that he formed the opinion that this twisting of this bag was the packaging of narcotics in his training and experience.
The judge credited his testimony in its entirety, right?
Yes, yes. So I think that's a key thing that I almost left out that I want the court to be left with as well. I think that I've only got 30 seconds, 25 seconds left, so I will rest on my brief. Thank you, Your Honors.
Thank you. For the defendant?
Good morning, members of the panel. May it please the court, my name is Elizabeth Moan, my pronouns are she, her, and I represent the appellee, Jason Denison. We ask that this honorable court uphold the district court ruling granting Mr. Denison's motion to suppress. At the time of the detention of Mr. Denison, there was not reasonable articulable suspicion or probable cause that Mr. Denison had committed a crime. As the Commonwealth notes, at the time that Mr. Denison was detained, he was immediately placed under arrest, and the standard is probable cause, but the district court properly found that the Commonwealth did not even meet the lower burden of reasonable articulable suspicion. I would like to address what the Commonwealth refers to as its best case, Commonwealth v. Stewart. I disagree with the Commonwealth's characterization that this is one that had fewer compelling circumstances. The court in Stewart relied upon the fact that this area was known to be an area that was popular with drug users because it was so narrow and they could step into doorways. And then they saw this group of 4 people meet at the start of this known drug street. One person was just seen counting cash. They go into a doorway, there's an exchange, and then they disperse. The other notable thing about Stewart is that the court only found reasonable suspicion and very specifically did not find probable cause. So even relying upon Commonwealth v. Stewart, I believe the district court's order was correct. The silent movie...
Do you agree with the Commonwealth that it would be a crime for the defendant to sell under 1 ounce of marijuana?
Yes.
Okay.
But also, as this court noted, there was no exchange of cash. And the exchange that happened at the car, the Commonwealth had described it as reaching into the white Mazda, but there's no facts that support that. Detective Simmons never describes the actions that he believed to be an exchange. He just states that he couldn't see what was exchanged because it didn't exceed the palm of the hand. But we don't have facts here, for example, where officers see hands meet and then see someone put something in the pocket. In this case, he doesn't see anything from Mr. Denison after what he believes to be an exchange. He does not.
But we have the going in the trunk, going in a plastic bag. We have twisting a different plastic bag.
Yes, and I think that the reason we don't see this in prior cases is because drug transactions are supposed to be quick and furtive. That's the language that we see in cases, and that's also the language that we see from this 25-year veteran detective, where he says Someone enters a vehicle. The purpose of, and this is page 43 of the transcript of the first hearing. The purpose of that is to shield the activity in the vehicle, whether it be from neighbors, surveillance units. The transaction can be done discreetly in the vehicle. To someone watching this, it looks like someone just getting in a car. And then on page 44, it's my training and experience. Short ride. It's made to cover the discrete transaction occurring in the car. That is inconsistent with someone twisting bags and allegedly packaging drugs out in the open. So the reason we don't see that is that's not what happens in these drug transactions.
Can I just stop you, though? I don't have a transcript.
Oh.
And you filed a supplemental appendix as well. Unless I didn't get everything downloaded onto my iPad, I don't have a transcript of these proceedings. You can continue with your argument, but
It shows filed on the docket, we just didn't get it.
okay.
I
so
have it. I have it.
It's somewhere, I will look for it. I don't have it, but I will find it.
Okay, when you
Okay,
do
but
look,
so is there any, but do we leave room for if somebody's not a competent drug dealer, can we still say, okay, well, they didn't, they weren't fast, but, they were sort of blatant about what they were doing, then that person can't get arrested in this situation?
no, but it informs what the detective can take from this silent movie. So he even testifies that by the time the defendant gets into the Mazda, he's not sure what had happened. And on page 37, he explains that it's only once Mr. Denison got out of the Mazda that he believed a drug transaction could occur. So he's watching this, and he, a seasoned drug detective, is not even sure what's happening.
Well, what is the explanation for the ride to nowhere? I mean, he gets out not very far away.
So I think that, when you live in a dense area like that, there are certainly reasons. We know that the parties are known to each other, and there are certainly reasons that you might start driving with someone and then decide you need to go back to your car, and it's faster for you to just walk than it is to continue driving with them or have them turn around. So this was also May 2020. It's possible he forgot his mask, and she said, I am not comfortable with you being in this car without a mask. It's possible that he forgot his phone in his car and she was running late and didn't have the time to take him back. It's possible that maybe they were going to smoke the marijuana and he remembered that he had to go meet his mom and he couldn't go with her. It's possible that in the car she told him she had a cold and he wasn't comfortable with taking the risk of COVID and he decided to get out right away.
So with all these possibilities, how do we factor in your client's affidavit in his statement in support of his motion to suppress? Can we consider his statements there where he said he was dropped off by an ex-girlfriend to pick up a rental car and that he never gifted her marijuana? Can we consider those?
So I don't believe that they were presented as evidence in the suppression hearing. He didn't testify. He wasn't subject to cross-examination. I believe.
An affidavit submitted in support of the motion to suppress, though. So how, if at all, can we consider that affidavit? Because that seems to be a bit inconsistent with your argument this morning.
So, well, that information was not, so I don't know whether, I don't think it's proper to consider it because it wasn't submitted as an exhibit, as evidence at the hearing. But even if it was, that information was not known to the detective at the time he ordered the detention. And so the question isn't what happened, it's what reasonable inferences could Detective Simmons draw from the silent movie that he watched. And so these are other possible inferences of legal activity.
So what can we consider on the question of this gifting? Because I don't have the transcript. Was that argued, was gifting argued below? And if so, how do we reconcile that with his affidavit that said he hadn't given his girlfriend weed?
So it was not explicitly argued below. And again, the question is not what happened, it's what inferences could Detective Simmons draw from his observations. And so here, we see what he describes as an exchange, but does not describe the behavior. But he doesn't see Mr. Denison take something from her and put it in his pocket. He doesn't.
I'm confused because on page 18, you say, as part of your argument, and I understand it's one of several arguments, that they didn't have reasonable suspicion because you can possess up to 1 ounce of marijuana and gift it. So are you asking us to consider something that the district court judge did not have before him?
So that is part of the argument that the Commonwealth did not have reasonable and articulable suspicion, and it's the Commonwealth's burden.
Right.
So the Commonwealth did not, that's the law, that you can gift marijuana. And the Commonwealth did not present enough information for an inference that even after they found the marijuana, this was more than a gift.
And the photograph on page 24 of your brief, you say that that's less than 1 ounce of marijuana?
Yes.
That was what was recovered in this case?
That is a photograph from the internet. We don't have a picture of what was recovered from the case, nor do we have a description.
Wasn't clear to me what that photo was.
I apologize. Thank you for the question, Your Honor.
Well, so I give you points for creativity for including it, but was that before the motion, Judge?
It was not, no. It's really informational. I think that sometimes when we're talking about drugs, a lot of the cases that come before this court are much denser substances. And so it's put there just to emphasize that 1 ounce of marijuana is an enormous amount of marijuana. You could not transfer that in an exchange, a palm exchange.
Yeah, but I thought the Commonwealth was saying he put it in the pocket of his hoodie. There was a bulge in his hoodie, and we never actually found out that the bulge was no longer in his hoodie. So that's missing too, right? I mean,
it is, and we don't have a description of the bulge either. So is it phone-shaped? Is it shaped like a bag of marijuana? We don't know. So there's significant details missing from this officer's testimony. And in Commonwealth v. Kennedy, the court talks about, on page 706, the court talks about the importance of extended testimony on the officer's inferential process. So where we have bare bones testimony like this, there's not enough to draw these inferences from.
so I noticed in your brief that you seem to challenge some factual findings as clearly erroneous, but you put those challenges in a footnote. And that's, we'll often caution parties that can result in waiver. Do we have to agree with you on any particular finding for us to affirm? Like I'm looking at footnote 2 and maybe footnote 3.
Do you know what page of the brief it's on?
28.
Thank you. Oh. Okay, so yes, I think that the exchange, one of the problems is that this court order was very short, and so I think that...
Yes, too short, one might argue.
But she does credit the testimony of the officer, and so I think when she says there was an exchange, I think that was kind of shorthand for there was what the officer inferred to be an exchange. But when we're looking at the details of this purported exchange, we don't have information about reaching. We don't have information about someone putting something in their pocket afterwards. And so I think the title of it is less significant than emphasizing that when the court says exchange, that is based on inferences that are not supported by detailed facts in the record. And that's in contrast to some other cases where the detailed facts are significant in finding that the exchange was an illegal
Well, so I hear you, but if the officer testified, I saw an exchange, then the judge can find that there was an exchange, even if it would be better if defense counsel or actually a prosecutor probed and said, what makes you say that? And they say, I saw them pass an object, or I saw somebody reach into the car.
So I don't believe the officer testifies that I saw an exchange. I think he testifies that on page 10 of the transcript, It appeared there was an exchange, either retrieving something or handing something in. And then on page 28, it appeared that something was exchanged. I can tell you that it was small enough, whatever it wasn't bigger than a hand where I could see them holding something.
Right, and that actually that's where Stewart actually seems to apply, because the SJC said that the officer didn't actually testify there was an exchange. But I'm going to go back to the question I asked you, which is, this is all in footnotes, it's not in the body of the brief, which is not a great idea, but do we have to agree with you to affirm? I mean, can we? Okay.
That's not an essential fact to this reasoning, because I think that even if there was an exchange, what we don't have in our prior cases is both an exchange and a supposed ride to nowhere. And that's because either one of these might have met a drug transaction, but there's no explanation for them to be both. Either there's an exchange or there's the drive. But there's not a single case that I found that has both. And that's because this interaction was missing the indicia of a classic street-level drug transaction. It was not brief, not furtive, not discreet, not in a high-crime area, which is a fact the court relies upon a lot, and none of the parties were known to these detectives. And then with regards to the twisting, the officer says that he saw some type of plastic on page 12, and that on page 31, that he couldn't see what he was doing in there. So I think that there was an inference that he was twisting the plastic bags, but he doesn't testify that he saw him twisting plastic bags.
Do you think our case law on this is clear?
I do, and I would refer to Commonwealth v. Beretta, I believe is the case.
Is that your best case?
Yes, that is my best case. Barretto, I apologize. And I see that I am out of time. Thank you very much, Your Honors.
Thank you. Thank you both. Our second case is case number 2022 P1187, the Commonwealth versus Robert J. Leonard.
Good morning. May I proceed?
You may.
Good morning, and may it please the court. Finally have a sunny day. Attorney Robert Spavento for the defendant, appellant Robert Leonard. Your Honors, if I may, I would like to start with my third issue, go a little bit out of order, on the issue of whether or not the judge erred and not bifurcating the license suspended due to a prior OUI.
Before you go there, and I promise you we'll have time, on the question of individual voir dire, if the judge got it wrong, do you still have to show prejudice? And if so, what is the prejudice here?
Your Honor, are you discussing the attorney-led voir dire?
Yes.
Yes. I'm sorry, can you repeat that one more time?
Sure. You say the rule requires the judge to allow for attorney-conducted voir dire, and that didn't happen in this case.
Correct.
Is that enough for reversal, or do you need to show prejudice? And if you need to show prejudice, what is the prejudice?
I do think that's enough, but if there is a requirement of prejudice, or what the prejudice is you come to court, you're ready to argue your trial, and you want probably your best opportunity to find out where the bias is in the case.
But didn't the judge ask all the questions in form and substance that trial counsel was looking to have asked?
I think he asked some of them. I didn't think he asked all of them.
So which specific questions did he not ask?
Well, if I take a half step back. So I think why it's a little different from, I swear I will answer your question, why it's different from an attorney voir dire versus the judge voir dire is the attorney, both the prosecutor and the defendant, know the case very well. It's going to, and this is a...
I think it would be helpful, we know the difference between attorney voir dire and Judge voir dire during impanelment. But I think it would be helpful if we're going to explore the question of prejudice. First of all, do you challenge Judge Blake's implication that you must demonstrate prejudice in order to get relief?
No.
Okay.
But if,
So if we're going to explore prejudice,
Wait, I thought you did. I don't know what the answer is. I just want to, earlier you said, no, the defendant doesn't have to show prejudice. Now it seems like you just said, yes, the defendant does have to. So what's your final answer?
does not, but if so, I have an answer.
Does not, okay.
okay. Well, that's interesting. I'm not, okay. We'll come back to that. Let me start with the premise, hypothetically, that you do have to show prejudice. It would be helpful to explain to us the substance of what was not brought out during the voir dire that did occur, and not simply identify the fact that the voir dire you would have liked did not.
Are you asking which specific question?
Not questions, content. I'd like to know what subject matter was not explored
Oh, okay, okay.
during the judge's voir dire
Okay,
that
I
the
understand.
attorney wished to explore during their voir dire.
I think the specific nature of this case, it involved a case.
I'm not asking them about the nature of the case. I know the nature of the case. I want to know what topics, what subject matter, what are you suggesting needed to be explored during voir dire that was not explored during voir dire?
Okay. I'm not trying to dance around your question, I swear.
Well, answering it would be the best way to avoid dancing around it.
I apologize, Your Honor. So the two topics, I think, the two big topics. First topic is what happened, can you be fair or something of that nature when you have the facts of him driving 100 miles an hour, going through Sagamore Bridge and driving like he did. I don't know how you asked that specifically. And the other issue, which is
those are the facts of the case. The judge asked the jurors whether they believed they could be fair and impartial, right?
correct.
Okay, what is it that you are saying needed to be asked that wasn't asked?
Those specific questions, he could draft it in a way that could you be fair if you heard the facts that an individual is driving like he was down the Sagamore Bridge at 100 miles an hour? Then the follow-up question, if he was intoxicated, could you still be fair listening to those facts? The facts are important in this case just because of the nature of those, of this case. And maybe probably the better question would have been, which I touch upon issue number 3, is knowing that he was previously convicted of an OUI, and this case involves an OUI. Can you still, even if I instruct you to, erase that from your mind, can you be fair and do that? Because we're all human. The judge can give the best jury instruction or the best limited instruction, but it's still in your head. And I understand that the SJC and the appeals court says when a judge gives a jury instruction, they're supposed to follow it. But I think we're all human in nature, and it's just there. It's the toothpaste that you can't put back in the tooth.
So your concern is the jury's sitting there thinking, hey, I drive over the Sagamore Bridge, this guy could have killed me, so I can't be fair?
Yes.
Okay.
So could you take us to which questions in the appendix? So you have the be fair instruction as the last piece of volume 1, and then in volume 2, there are 38 proposed questions. And you're saying that the judge didn't ask any of these, some of these?
So,
I mean, there's specific ones that it looks like in
Oh,
the
okay.
judge's writing, he wrote denied.
correct. I think it goes to the issue of, especially once the judge says no to attorney voir dire, attorney conducted voir dire, it doesn't allow the trial attorney to expand upon it. He's stuck with the questions that he next proposes for the judge to read.
I guess, though, that's where I'm getting stuck. Is the denial of attorney-led voir dire an automatic reversal? And if so, what do you rely on? And if it's not an automatic reversal, through what lens are we looking? Are we looking at abuse of discretion? Are we looking at whether it was prejudicial error? And if it was prejudicial error, what was the prejudice to your client, and which specific questions were not asked that you say is prejudicial?
Okay, thank you. Yes, I think if an attorney requests the attorney-conducted voir dire and the judge denies it and says denied,
Automatic reversal.
I think he should.
Do we have a case?
No.
So this would be the first case that would say that.
There's very little case law, especially on the district court standard order. There's a little bit of case law on the superior court
So do
standard
we have a
order.
Superior Court case that says denial of attorney-led voir dire is an automatic reversal?
No, we do
Okay.
not.
So let's put that aside for just a moment. Let's assume we have to do some sort of an analysis beyond that. What are we looking at? Are we looking at, did the judge abuse his discretion? Are we looking at whether it was error, and if so, was it prejudicial to your client?
I would like it to be prejudicial error, but it's probably going to be abuse of discretion.
All right, let's go with what you like. You like prejudicial error. What's the prejudice?
Is the trial attorney's inability to further go through
Of
the,
all 38 questions?
or even, it doesn't have to be a 38 questions.
That's where I'm trying to drill down to understand. The judge didn't ask this question, and this prejudiced my client because. I understand philosophically, you know the case better than the judge is ever going to know the case, so you have a better feel for the case, but we don't decide it on feel. So what question wasn't asked that you say prejudiced your client?
I don't think there's one specific question.
Okay.
So it sounds to me as though your answer to Judge Blake's request about prejudice is in substance a path to the same conclusion that a denial of a request for attorney voir dire is automatic reversal. Because it's the fact that the prejudice flows from the fact that the attorney was not allowed to conduct voir dire, not the substance of what was explored or not explored. At least that's what I understand your answer to Judge Blake's question to have been.
Are you saying, Your Honor, that
I'm just restating what I understand your argument to be. If I'm misunderstanding your argument, please set me straight.
So what I'm not saying is if I come up with, say I don't want the attorney-conducted voir dire.
No, if the attorney requests voir dire and the judge says no, you say that should be automatic reversal, but you don't have a case to support that. And then Judge Blake asked you, well, if it's not automatic, then are we looking for prejudice? And you said yes. And then she asked, well, what would be the prejudice? And your answer was, as I understand it in substance, the prejudice is that the attorney didn't get to conduct voir dire. And that seems to me to get us back to where we started.
It
So
does.
I'm looking for a more, and I think Judge Blake is looking for a more particularized indication of actual prejudice, not philosophical prejudice.
I don't think there's a possibility to come up with an exact prejudice, but, I mean, there has to be something.
The purpose of voir dire is to examine whether the jurors carry undisclosed or unidentifiable biases into their deliberations. And the way we get at that is by conducting voir dire. That voir dire is directed toward a series of topics that examines the jurors' life experiences and thought processes. And if the judge asks all of the same questions that the attorney would have asked, doesn't that accomplish the same goal in substance?
It could, yes.
Okay.
Is there any indication in the record as to why the judge denied the motion?
No, so what happened was the attorney filed the motion requesting to do it, and it just said denied without a hearing.
Okay. The Commonwealth makes an argument that I understand you have an argument that under the standing order, the motion was timely. The Commonwealth is saying under the rules of criminal procedure, it had to be filed by a certain date. If the rules of criminal procedure control, was the motion timely filed?
First, I would argue, Your Honor, that that argument was not presented at the trial court level, and I filed...
Why would it be the judge denied your motion?
I'm sorry?
The judge denied your motion, so why the Commonwealth didn't even have an opportunity to make an argument?
They could have also filed, because he renewed his motion at trial, and the judge still said denied.
Right.
And the Commonwealth didn't present an argument. But even if they did, I think there still has to be some flexibility in filing of motions. I understand that, shall means shall and may means may, but I think there has to be some flexibility in trial courts with filing motions and of whatnot, especially in the district courts where, you could have 12 different trials scheduled for that day, and you don't really know if you're going to go. I think there needs to be some flexibility, even if they are...
Don't we know a little bit about why the judge denied it? At transcript 1, from pages 22 to 33, there's a discussion about the individual questions, and the judge basically says he doesn't want to avoid redundancies. Then there was some questions asked, defense counsel asked for follow-up questions. The judge, in fact, asked those follow-up questions, and then when the judge found the jury indifferent, there was no objection to that. Did there need to be an objection there to preserve this question?
I would argue no, because he did argue it both at that motion filing.
As a motion in limine.
Yes, I would. That would be my argument.
So we promised you that we would let you have some time on bifurcation.
I could be very fast.
Great.
The main argument, I'll just get right to it, in the Bailu case, if I'm saying it correctly, it states that while bifurcation is judge discretion, it is a possibility in the case. Justice Henry asked the prior attorneys, what's your best case? I don't have a best case because I don't think this has gotten to a point to the SJC or any other court that says, this is fine, you can do that. And if this case doesn't do it, say bifurcation, I don't think there's any case. The facts were terrible. He was driving 100 miles an hour, hitting trees, people crossing over, and how else can the jury say, oh, he's convicted of it before, he did it again?
Does it matter that, because the Commonwealth says it does, that the document that came in to support that was the registry materials and not the certified conviction? Does that matter?
No, because on the exhibit number 9, it says license suspended at DUI liquor 2008. So the jury saw it. Whether it's a docket that says he's convicted or that document, the jury knows he's been convicted. If there are no further questions, I rest my brief.
Thank you.
Thank you for the extra
For the
time.
Commonwealth.
Morning, Your Honors. May it please the Court. Rose Ellen L. Corey for the Commonwealth of Massachusetts.
What's the remedy?
For,
The standing order says shall.
the standing order does say shall. The Commonwealth, in our main argument, does...
Putting aside the timing for a moment, I'm curious as to what the remedy is when a judge flat out denies attorney-conducted voir dire.
Of course. The balance of the case law makes very clear that the manner in which voir dire is conducted falls soundly within the discretion of the trial judge. And so I would argue...
Wasn't that discretion constrained by the standing order?
It is, and I apologize because...
Or are we going to apply a different meaning to the word shall for this purpose?
I apologize because I've jumped ahead thinking about jury questions and have not responded to the question, so I apologize for that, and I will slow myself down. I think if this court finds that it is shall, and if the rules of evidence do not apply to this case, then I think shall means shall. And if the...
What do you mean if the rules of evidence do not apply?
As the timing argument that the Commonwealth...
That's not rules of
The rules of
evidence.
criminal procedure, okay.
Yes, I'm sorry. You can tell that I skipped anything with caffeine in it this morning. I apologize.
The time change is not till next week. We're just all gearing up.
But if the rules of criminal procedure do not apply to this and the timing argument does not apply, and this court finds that, as was stated, shall mean shall, if it's
That's not a finding, that's just an interpretation of the language, right?
Yes, it is, Your Honor. But if that is the case, if there is no discretion for the judge and there was no issue with timing.
Well, then it would be a clear violation of the standing order. Then we get back to Judge Blake's question. What is the remedy?
Yes, and the Commonwealth would argue that, again, since the balance of the case law surrounding how voir dire is conducted puts it within the discretion of the trial judge, the question would be, was it an abuse?
But that case law, the case law in your brief all predates the standing order.
Yes.
Okay, so we now are operating in a world where the guidance from those cases, at least for purposes of proceedings in the district court governed by the standing order, it doesn't offer us much assistance. And our question is, again, when there is a violation of the standing order, what result?
If there is a violation of the standing order and the defendant is entitled and has properly requested for attorney-conducted voir dire, I think this panel is aware, as I am, as much as I don't like saying it, that the proper remedy for this, it is a structural error. If it does touch on the defendant's rights to have an impartial jury, then reversal may be the remedy in that case.
And does the defendant have any showing outside of the failure to grant the request? In other words, is prejudice a question?
I think it would have to be. I think that this, it is a standing order. It does have full force for the district court, but I think there would have to be some showing of prejudice, because otherwise, what have we been doing for, the past history of the Commonwealth?
If we liken it to the other structural error cases like closed courtrooms, did that require prejudice, or did the fact of the closed courtroom require reversal?
The fact of the closed courtroom does require reversal. I would argue that this is somewhat different, because even when an attorney is not conducting the voir dire, they do have input into the process. As was seen here, the judge did ask questions that the attorney wanted to ask himself. So I think there's a little bit more nuance here.
Certainly, the judge has discretion as to the scope of the questions, right? I don't think your brother counsel would disagree with that, but what is the showing? So the defendant says it was shall, the judge didn't do it, therefore, finish the sentence for me. Therefore what?
Therefore, from the defendant's perspective?
Either way.
Therefore, the court would turn to inquire the impact of the denial on the defendant, I would say.
I.e. prejudice.
Yes.
So let's say that somehow let's say the judge has had this lawyer before and thought the lawyer was a little slow, but doesn't say that out loud. And so the lawyer says, I want to do attorney voir dire, exact case, exact same facts, but two different cases. And the judge says no, but the judge asks every single question that from the prior case that he thinks the lawyer's going to ask. Do we have to reverse in that situation?
I mean, I would say no, because I would look to, assuming that those questions are the questions that the attorney would have requested or asked himself if he had conducted the voir dire, I would say no. I would say it doesn't, because there has been no prejudice to the defendant.
Going the other way, could a district court judge just say, I don't like this attorney voir dire, it slows everything down, so I'm never going to grant one of these motions ever. That's my discretion. I don't like it.
I unfortunately don't think that their discretion is quite that broad. I do think, as has been pointed out, the standing order does say shall.
So that's where we get into the challenge of applying this rule to this setting, because a judge who, as Judge Henry has identified, simply objects on principle to the idea of attorney-conducted voir dire, undertakes a practice of denying the requests as a matter of routine, and then is able to defend that practice by asking the questions that the attorney would have asked in open defiance of the standing order.
I think in that case, it would be incumbent upon the parties, including the Commonwealth, to bring to the judge's attention the perhaps lack of...
Right, and then the judge says, thank you very much, but this is the way I do things in my courtroom.
It's, well, then I think, and I hate to bring more work before the court, but I think then you file an emergency stay and an appeal of that decision, which is the normal way we conduct.
Well, or maybe when the judge does that without justification, ignores the meaning of the standing order, we reverse without requiring a showing of prejudice.
Potentially, yes, if it's...
And the defendant gets a new trial in which the judge follows the rule.
Yes, if it's a timely filed motion, I absolutely agree.
So there are two rules that, as I understand things, that govern the timing of pretrial motions.
Yes.
One is the rule that talks about pretrial motions generally being filed within 30 days after the trial date is established.
I believe it's 21 days.
Right, and the other one, whatever it is, and the other one is a rule that talks about any motion directed toward voir dire.
Yes.
That says it has to be filed at least 5 days before the trial date.
Yes,
This was filed more than 5 days before the trial date.
it was. But it was also filed more than 21 days after the final pretrial.
Doesn't the specific govern the general?
I would say not necessarily in this case. I think the fact that you can file up to 5 days takes into account the fact that you may have a final pretrial hearing, 2 weeks before a scheduled trial.
Or it may be that the reason that there's a specific rule directed toward motions concerning voir dire recognizes that the question of voir dire is one that is best considered at a point that's close to, but not on the eve of trial.
That is a possibility, but, the Commonwealth maintains that given the rules of procedure, the defendant's motion was untimely, and he did...
Can the judge allow or entertain a motion that's filed out of time?
He does have discretion to do that.
The judge engaged this motion on its merits, not on the, he didn't deny it on the basis of timeliness, right?
I don't believe there were any substantive findings. I think it was just denied with no explanation.
See, my concern is, and I would be interested if you have a case that says that the rules of criminal procedure trump a standing order, but my concern is if we interpret things your way, then what we've basically said is that the court has set a trap. And you'll know from at least my cases that I don't ever want to interpret that the legislature, or in this case, I would say that the judge or the chief judge of the district court has set a trap, right, by setting up this inconsistency and said, here, you can wait until 5 days before trial, and then an attorney does that because it's right in the standing order, and then we're like, yeah, no, that was just, we gotcha.
I understand, and I do understand that in district court, things move very quickly, timelines are very short, but I do think the rules of criminal procedure apply to non-discovery pretrial motions for a reason, and I think that...
What's the reason?
So that everyone has fair notice of the issues that will be raised, everyone has enough time to file their objections to any motions that are filed, or agree to them, so that people have a rough, people who are practicing on the district court level have a rough idea of the timeline they can expect to receive certain things. So, as I said, my interpretation of the 5 days in the standing order was that there, you can have a very tight turnaround between trial, or between your final pretrial conference and your trial. So if you have that, you still need to give the court sufficient breathing room with your notice of your request for attorney-conducted voir dire.
Is there a way to interpret the standing order and its limit of 5 days, at least 5 days before trial, to not set a trap?
I honestly, I don't read it that way. I think that if you're aware that you have 21 days after your final pretrial conference to file any motions that occur to you afterwards, you can do that within the, you know that if you're going to request attorney-conducted voir dire, you have your 5 days. I think it's just a question of doing the math, for lack of a better phrase, going and checking what governs, the admissibility of your motion.
Right, but then shouldn't the district court have just put that in and said this is governed by whichever provision of the rules of criminal procedure, the timing, and then everybody would know? This way, you've got to say, oh, this says I can do it 5 days before trial, but wait a minute, and they have to think on their own, oh, the rules of criminal procedure say, no, I got to do it at least 21 days after some other date, not even 21 days before trial.
I don't think I'm in a fair position to comment on how thorough certain statutes, orders, or overlapping guidance might have been at the time it was drafted.
Do you know if we have a case that says the rules of criminal procedure trump a standing order?
I do not have one off the cuff. I'm happy to supply any supplemental briefing if this court would like that.
Why don't we talk about bifurcation?
Of course. So to sort of cut to the chase on this, I think that the Commonwealth's best case on this issue is Burke, which is the unpublished decision that I included in my brief.
Why don't we stick to the published opinions, the ones that actually are binding, presidential?
So the facts of Burke closely match sort of these circumstances, which is why I would call it our best case. But the standard here is an abuse of discretion standard. This is not an abuse of discretion. The defendant here is arguing that the admission of this one page, or several pages, but one indication from the RMV regarding a suspended license for reasons of a previous OUI, and the letter notifying him of that license suspension is impermissible bad act evidence. And here you're looking at a redacted driving record. It wasn't referred to in the prosecutor's closing.
The redaction did not excise the problematic material, though.
Well, it excised a lot of other potentially problematic material.
It's the fact of suspension, not the reason for suspension, right?
Right. This is just being offered to prove that the defendant was driving with a license suspended for this reason at the time.
Had the RMV record been redacted to reflect only that the license was suspended and not the reason for that suspension, we wouldn't be having this conversation.
That's true, but he was charged, I believe, with operating with a suspended license suspended for OUI. I may be misremembering.
Okay,
but
so in that case, the judge has an available remedy to separate that and to conduct that second trial without a jury, right? Isn't that commonly done?
Yes, that is correct. I would refer the court for published opinions to Commonwealth v. Furr, 58 Mass. App Court 155, page 161, which again just outlines that we routinely expect jurors to limit the consideration of certain evidence, and here they received the limiting instructions and are presumed to have followed it. And I can see that my time.
There was a very clear and emphatic limiting instruction here, but then we get it. Okay. I see that your time is up. Thank you.
Thank you, and happy birthday, Your Honor.
We move to the third case on our list, case number 2022 P912, FTI LLC and another versus Robert J. Duffy and others. And just as a reminder, we will be taking a recess after the conclusion of the argument in this case.
Good morning, Your Honors, and may it please the Court. Derek Schaefer here on behalf of the defendants' appellants. Your Honors, this outlier judgment awards FTI tens of millions of dollars, including $18 million in punitive damages, despite the absence of any sound legal theory or record evidence supporting it. Before discussing obvious and important errors of Maryland law that render the jury verdict infirm and dangerous for employees, I want to highlight, if I may, the problems with the 93A award. As we've noted, FTI adopts a narrow view of 93A misconduct in trying to ground its case against BRG in Massachusetts, but then flouts those limitations when purporting to justify baseline 93A damages of $12 million. Because FTI can't have it both ways and lacks any evidence that these claimed damages were caused by BRG's alleged 93A violation, as is statutorily required, this Court should reverse. And let me start, Your Honors, with the primarily and substantially limitation of 93A. BRG established undisputed facts refuting the notion that the fact pattern, the alleged misuse of FTI's confidential information by BRG, the lone 93A defendant, occurred primarily and substantially in Massachusetts. Constitutional concerns align with statutory text in precluding extraterritorial punishment by Massachusetts, which is effectively what we wind up with in this case. And let me note at the outset, Your Honor, that we have out-of-state parties on both sides of the caption, BRG and FTI. That's different from what you'll find in any case that finds requisite Massachusetts nexus. Beyond that, Your Honors.
And you say they're out-of-state parties, you mean the state of their organization?
That's their headquarters and their headquarters and their incorporation.
But the activities that we're concerned with here principally surrounded personnel in the Boston office, right?
Well, Your Honor, I think it was of the departing employees, to be precise, it was 16 out of 33 apart from the individual defendants who were coming specifically from the Boston office. And then that left 100 employees in FTI's Boston office. But as to the bottom line impact on FTI's balance sheet, that's happening, Your Honor, in Washington, D.C. and in Maryland. The clients who impact that, virtually all of them, with the exception of one, they're all out of state. The recruitment, according to the record, every bit of it is happening outside of Massachusetts. The retention payments that FTI claims as damages, those are almost exclusively flowing outside of Massachusetts. And, Your Honor, the employment agreements that are at the core of this are governed by Maryland law. Sorry, Justice
I thought you were saying that that FTI admitted the recruitment can't be the basis for this liability.
They do, Justice Henry, but in order to get to the damages, it's all because of the recruitment. So
Okay,
FTI
but I'm
really
a little
is.
lost because you said 16 of the 33 employees who came were from the Boston office.
That's right, Justice Henry.
Right, so there was a big impact on FTI's Boston office in terms of personnel, right?
Well, just to put it in perspective, it's more than 100 employees who remain in Boston.
Okay.
So it's 16 out of the 100. And in many cases,
But it's not the impact on FTI's Boston office so much as the center of gravity of the activity that gives rise to the complaint, right?
Right, Chief Justice. And the activity is that of BRG, the lone 93A defendant. And there's nothing that BRG is shown to have been doing in Massachusetts. That's why FTI points to the fact that—
Well, not until they poached the 16 employees out of FTI's office, right?
I just mean that the activities that are causing that. To take the Skyhook v. Google case that this court decided, and we cite in our papers, there you had Google doing things allegedly in California. International conduct is also true here, and ultimately an impact in Massachusetts, the court acknowledges. But that's not enough to make the center of gravity here. I'd also point out to the court that the Superior Court itself, you can find it at A2, 106, and 107, specifically noted that under the traditional factors, there's no one state that has the center of gravity, and that the individual defendants who were supposedly, part of this whole scheme by BRG, they were out of state and they were international in terms of their activities.
But one thing that you've left me confused about is, let's say that you're smart and you know about Massachusetts law, and so you schedule all the recruiting meetings in New Hampshire, and you basically steal the entire Boston office. Are you saying the center of gravity can't be in Massachusetts because you just said, come have a cup of coffee across the border?
Justice Henry, that's a tougher case than what we have here,
Okay.
obviously. But there's no such indication that BRG was specially gerrymandering its activities. These are organizations that operate nationally and internationally. Again, they're based outside of Massachusetts. So it was perfectly natural for BRG to be having its recruiting meetings, as the record reflects, in New York, in Washington, D.C., and in Maryland. That's where these activities are happening. That's where FTI is feeling the financial impact.
So who had the burden to prove that the activities did not primarily occur here?
We did, Justice Blake, and we did that through the undisputed facts that I was mentioning.
And so then you waive findings, right? So we review this like we would review a jury verdict, right?
Well, Justice Blake, we didn't review challenges to sufficiency of the evidence or appellate review, and this is a de novo question. Once you have the facts, the question whether Massachusetts is correctly deemed the center of gravity, that is decided as a matter of law. And again, you have from the district court,
Well, but there
of
have
the
to
Superior
be,
Court.
there have to be facts there has to be a constellation of facts that make up that center of gravity, right?
That's true, and you can.
And we don't have the benefit of the trial judge's findings on that.
And I don't mean to deny my friends for the other side the benefit of all inferences that could be drawn from the proof, but what I was reciting to the court are really the undisputed facts combined with what the Superior Court found at A2, 106, and 07. I would commend that to the court so you can see the factual premises that lead to what we think is the incorrect legal result. Alternatively, Your Honors, if you don't believe that argument, then let's turn to the amount of these damages. There is no amount of damages, let alone $12 million worth, that was proved to have been caused by any Massachusetts-based 93A violation by BRG. And so this poses a problem not only under the statute, but the U.S. Constitution, because essentially what FTI is trying to do is recover from a nationwide and international fact pattern under auspices of a punitive statute peculiar to Massachusetts. As Your Honors noted, FTI concedes that recruiting is irrelevant for these purposes. You can find that in FTI brief at page 24. They acknowledge the same below, and that settled law requires distinctness for the 93A violation. You can find that in their closing at A3974. The Manning case from the SJC establishes that FTI could not make a 93A case out of the mere fact that Mr. Duffy and the individual defendants breached their non-competes. So as
Can
FTI...
I just pause you for a moment, because you keep saying recruiting is irrelevant, but you mean, I think, that recruiting the individual employees from BRG. You're not talking about recruiting customers.
Well, Justice Henry, I do think they say recruitment, I think they're right about that across the board, because the breach of the non-compete, which justifies the contractual theories on which FTI recovers under the jury verdict, that cannot ground the 93A recovery. The 93A theory, as I understand it from FTI, is specifically that BRG was misusing FTI's confidential information. And that alone should be a red flag, Your Honors, because this is not a case where you have trade secrets or something that is moving outside of FTI. And never should see light. It was just compensation information, the likes of which BRG was able to acquire from LinkedIn and from conversations with individual employees. And FTI has rightly disclaimed the notion that mere recruiting, whether it's customers or whether it's clients, can be the basis for its 93A recovery.
Well, but if the issue is misuse of the confidential information, then isn't that really a question of fact for the fact finder and not necessarily for us if there's any information that confidential information was misused, or maybe they didn't believe you that you could just get it readily from LinkedIn. I mean, our legislature is working on a whole law about salary transparency, which implies it's not transparent.
There needs to be record evidence of causation and damages. And that's what is totally missing here. Because, Justice Henry, if you look at FTI's brief, page 20 and 21, they note that Mr. Duffy was the Pied Piper. And the mere fact that he left FTI in alleged violation of his non-compete meant that customers and colleagues were going to follow him. That's not a 93A violation. That's not being caused by any misuse of confidential information. That's inherent in him departing, as he can do, without 93A coming into play. So their damages theory for the contractual recovery in front of the jury was necessarily distinct. They acknowledged it was distinct, and then they offered no proof whatsoever, and I do mean that, no proof whatsoever that a penny of their damage was caused specifically by the alleged 93A violation. And so that leads them in their brief to cite a scattering of record citations none of which indicates.
Well, on that smattering, what's the relevance of the so-called Super Bowl spreadsheet?
Justice Blake, I leave it to my friends for the
I'll
other side.
ask them, but
to
I want to know
explain
what
that.
you think.
They'll say it contained compensation information, all right, specific compensation information for potential recruits. But that compensation information, Justice Blake, there's nothing that suggests that that was worth $100,000 or $1 million, let alone $12 million, because everything on there could be ascertained just by asking a potential recruit, how much do you make and what do you want to make with us?
But
so
weren't
it's all
they
comes down
getting
to
that
recruit.
information by working for FTI?
Right.
But, Justice Henry, BRG could obtain that information through other means, and there's no evidence that traces BRG's acquisition of the information to this Super Bowl spreadsheet. Nothing. There's not even evidence that
Doesn't
BRG
having
had
that
it.
information allow them to develop a plan for how they're going to move forward, who they want to target, and what they want to use in that initial approach?
Mr. Chief Justice, no one so testified, and there's no.
Well, isn't that the whole, I mean, I don't think you need testimony specifically. That's the whole point of gathering that information as part of this plan.
I think it's contrary to common sense and the testimony that BRG had means of getting this same information and did not acquire it through the Super Bowl
Well, did
spreadsheet.
FTI admit that, or was that just BRG's testimony because the finder of fact didn't have to buy it?
What they said is that they're not basing this case on recruiting, and they're not basing it
Which
on
is
mere
why I'm
breach
going
of
to
the
come back
non-compete.
to, and I really want a crystal clear answer. When you say recruiting, do you mean just the employees, just the executives, or do you mean both?
I mean both, Justice Henry.
Okay.
Because 93A is a special statute that prevents unfair competition. That does not mean that if you have preeminent talent that leaves one employer to go to another, that clients who follow them are doing so in violation of 93A or with punishment to be heaped upon the
You're running low on time. I'd like to spend a little bit of time talking, I can't believe I'm saying this, but I'd like to spend a little time talking about Maryland law.
Very glad to, Mr. Chief Justice, so thank you for moving me there. Note, Your Honors, that the individual defendants are liable for more than $20 million in damages while disregarding the established limitations and protections for employees under Maryland law. That will menace and intimidate countless employees absent correction. If Your Honors find an error of Maryland law, then on constructive discharge, then the whole 93A award falls away because as the Superior Court acknowledged at A2, 117, 18, and 303, the underlying 93A theory would not be in play if there had been a constructive discharge.
All
If
right,
the
so-
employees were the individual defendants
So
were no
time
longer
is
employed.
short, and assuming we agree with you that the judge gave the wrong instruction because inexplicably he didn't just read the standard that's stated in the case, what's the prejudice?
The prejudice, Your Honor, is clear, and you have it actually from the judge himself at A3888. The Superior Court noted that the jury could find that the defendants were constructively discharged because Mr. Duffy.
He allowed the claim to go to the jury, but the theory, it seems to me, has a high degree of overlap because the very nature of the facts that you are depending on for constructive discharge suggests that they were grounded in a plan to clear out the executive leadership.
I would disagree with that, Chief Justice, because many employers want employees to stay under disadvantaged conditions because they're sexually harassing them, because they're racially discriminating against them, or because they're lowering their compensation.
Is there any evidence of that in this case?
Yes. Mr. Duffy's compensation was reduced by $500,000 below what was contractually guaranteed. You have the other individual defendant testifying he couldn't get out of bed every day. They were being basically smacked down by their employer and stigmatized, but they wanted, Mr. Chief Justice, for the same reasons that they're arguing, that these were very preeminent individuals who had client and followings, they wanted them to stay. And that was FTI's testimony.
They had a funny way of showing it, didn't they?
Well, Your Honors, but that's true of many employers who are creating intolerable conditions, and as our amicus from PJC points out, the legal requirement that was imposed by the district court to show specific intent is virtually impossible to satisfy in practice. It is a much higher bar. It played into FTI's testimony, so this is a case where it's not only, it could have changed the result. I think it likely changed the result. You have strong indications of prejudice.
So how do they say you're getting $500,000 less than your written contract unless they terminate that contract?
Well, but we have another argument, by the way, that he'd been promoted and then demoted, which is a separate thing that the judge did not allow to go to the jury. But I do think, Justice Henry, oftentimes employers want to get by on the cheap. They want to disadvantage their employees, deny them rightful entitlements. That translates to a claim for constructive discharge, even if the employer says, and I still wanted the employee to stay, as most employers will.
So on the directed verdict, I can't tell how many arguments you're making. So again, because we have the law students here, it's very helpful if you say, we're making two arguments, they're separate and independent, or they're not separate and independent, but you at one point say initially, and you argue a bunch of stuff, and I can never find the next argument, or at least it wasn't clear enough to me. So how many arguments are you making under the directed verdict? Because at least if I know how many there are, I might have a chance of finding them.
My apologies, Justice Henry. There are two distinct arguments on constructive discharge.
I had a feeling.
One is the erroneous jury instruction that we were just talking about. The second is the judge granted a directed verdict, did not allow BRG and the defendants to argue a distinct theory of constructive discharge, which was that Mr. Duffy had been promoted and his contract had been orally modified such that the demotion down from that was a constructive discharge under the Weissman case and Maryland law.
So their response to that is, look, leadership, and perhaps we might be getting ourselves confused, but some of us were at large law firms, and their response is going to be leadership changes all the time at these big organizations, and that has some resonance, at least for somebody who was at a large law firm, because it does, it changes all the time. What's no big deal?
Maryland has said that the question of whether there was an oral modification of the contract is classically a question for the jury, and here the initial contract said that Mr. Duffy would be reporting to himself, given his new position. That doesn't make sense. That results in absurdity. That's reason why the jury could decide whether there'd been an oral modification of the contract. If you agree with that, the jury should decide that too. And I rest on my briefs as to the question of the duration of the term, which was not, which was fixed and then not expanded.
Justice Henry has one more
I just
question.
want to ask you one more question. So their response in the brief, and I'm unclear what you're saying, is that you can't possibly say these people were, forced into this horrible situation because they were still making millions of dollars. What's your response to that?
The Wiseman case from Maryland, where you had a highly paid executive who had a successful or a viable constructive discharge defense precisely because he was not given the benefits.
We're over time, so I got it. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. John Siegel for FTI. We agree with one thing my brother said, so let's start there. One thing only. 93A, he said, is a special statute that punishes unfair competition. And that's exactly what happened here. This was a lift-out raid calculated by BRG using its agent, Bob Duffy, who was under contract simultaneously to BRG for the future and FTI in the present, who violated his duty of loyalty to FTI by sharing and exchanging and coordinating and quarterbacking this raid during the 90-day notice period while he was still employed.
Right, so
at
they
FTI.
argue, though, that you're trying to have it both ways, and that either the 93A judgment should be reversed because this was really a nationwide recruiting situation, or it has to be vacated because there's a lack of connection to Massachusetts.
No, this was centered in Massachusetts. The 93A predicate violation was aiding and abetting breach of fiduciary duty. That's Mr. Duffy's breach of fiduciary duty to FTI for the benefit and as the agent of BRG. Now, you asked about the Super Bowl document, and it was
But
minimized.
before you go there,
Yeah.
you're describing it as a breach of fiduciary duty, but it's also a breach of contract. And I'm not sure I can readily see why it extends beyond breach of contract. It's a breach of the express provisions of the contract about confidentiality and non-competition. Where does from what source does the fiduciary duty arise that carries this out of ordinary contractual breaches into the world of 93A?
The violation of the duty of loyalty as held in the Governor Law case, which held that a theft of confidential information for the benefit of the new employer while still employed by the old employer is an appropriate basis for a 93A finding of violation. There were two trials here, And they're arguing the 93A primarily and substantially issue under the other trial. We tried the breach of contract case and the tortious interference case to the jury. It's the aiding and abetting breach of fiduciary duty case, the 93A case, that was tried to the judge. And the SJC says on primarily and substantially that contract cases differ from tort cases and that you look only to the misleading or unfair acts to determine primarily and substantially. That's the Skyhook case. And you look at the purpose and the intent of 93A. This isn't some contract case where there were two companies that were in privity and you look to where the contract was formed and where the contacts took place. That's Kuwaiti Danish. That's not this case. This is a breach of fiduciary duty case, and you look to where was the breach of fiduciary duty, where was the confidential information located.
What were the BRG activities then?
I'm sorry?
What were the BRG activities? Because they're the only they're the only defendant under 93A, right?
Yes.
So it was what? Receiving confidential information?
So the Super Bowl document has been completely mischaracterized here. I didn't name it the Super Bowl document. Mr. Duffy and Mr. Coulomb named it because it was the whole ballgame. It was literally a document into which they put during the period when they were leaving FTI but still employed all of the information about the business that was being planned at BRG. They had it on a thumb drive, and the only reason we have it is that someone closed the laptop before removing the thumb drive. So we captured a lot of the information in the extra space of the laptop. The document was created by Mr. Coulomb in February of 2016, and it existed until May 23rd, 2016, when Mr. Duffy returned his computer to FTI. It included a practice model, a P&L, for the new business being created at BRG. One of the items in that P&L was a deal point list that included excluding litigation and settlement costs from the P&L of the business that they were creating.
Right, so those three guys did that. What did BRG do?
No, those three guys, that's literally the record of the negotiations between the two of them. They had BRG's profit model in their computer. They could only have gotten that from BRG. Mr. Duffy admitted that he had continual calls with BRG during that period, that he received compensation information. It wasn't just FTI's compensation information. It was the BRG information about their negotiations at that time with FTI's employees that they were sharing with Mr. Duffy, because the inference is they were coordinating on the recruitment. They were coordinating on it. They had a status report of who was going to come.
He says that you say the recruitment, let me ask you the first question, which is do you agree the recruitment can't be part of the 93A? Or do you disagree with that?
The misuse of confidential information as a breach of fiduciary duty is 93A. The recruitment alone, someone from BRG calling an FTI employee and saying, come work with us, no, that's not the 93A case. It's the misuse of the confidential information. It's the coordination between BRG and Duffy. It's BRG's use of Duffy. And let me say this. The laptop with the Super Bowl document was returned in Boston. They worked in Boston. There's a 3-month period where this document existed. They had every opportunity to prove that they took that information out of the state and used it out of the state, and they never did. They presented no such evidence at all.
As you know, the record in this case is fairly extensive. Where can I find the Super Bowl spreadsheet in the record? You've given us a lot of record citations about testimony concerning it, but I'd like to see the document
You can
itself.
find it two places, Mr. Chief Justice. First, it's Trial Exhibit 161 in 3 different forms. That's at A9-181. It was admitted by stipulation in which the defendants admitted that they had this on a
I
separate
have no doubt that it
license.
was in evidence. I'm just looking
That's
to
at
see where I
A3,
can put my own
242.
eyeballs on it.
A3,
242 is the stipulation. A9 181 is the exhibit itself. The information that was misused in it is at A9 191. That's the chart showing who was definitely likely and probably to come. A9 195 is the BRG Senior Management Director Compensation Negotiation information, the BRG information.
but the
A9
BRG
190
information can't be the basis for a 93A liability.
Excuse me?
BRG's confidential information cannot be the basis for a 93A liability.
FTI's employee, the evidence of FTI's employee coordinating and consulting on BRG's recruitment of FTI employees while he was still employed by FTI is most certainly a breach of the duty of loyalty.
So BRG says the Superior Court struck its 93 damages award, the $12 million. And when you look at the Superior Court order, it says that the damages the jury and the court awarded overlap and are intended to provide compensation for the same injuries. And then it says, as a result, when the final judgment enters, it will provide all four defendants are jointly and severally obligated to pay the $21 million. So why are they wrong about that?
Because that was the Superior Court applying a consistently held standard in the case law, in the Callum Lim case, the Costa versus Brait Builders case.
No, but they could have reduced the $21 million down to $9 million. I mean, what you got was that BRG is jointly and severally liable for the breach of contract, although I don't think it was a defendant for those claims. And it could have, the Superior Court could have maintained the $12 million 93A award, but he didn't. He seems to have put them together.
First of all, BRG was liable for the $21 million
It
under
was,
a tortious interference with contract claim.
Okay.
Secondly, under the cases I mentioned, and another one not in our brief recently, H1 Lincoln, at 489 Mass 1, the SJC has consistently held that where there's overlapping damages and duplicative damages, the 93A damages take priority. And that's what the Superior Court did. And he did it because 93A is an unfair trade practices statute. It's a regulatory punitive statute. Its whole purpose is to prevent people from doing what BRG did here, which is breach the contract, interfere with the contract, lift out all these people, pay lost profits 6 years later, and be done with it. It's a cost of doing business. The reason 93A exists is to prevent this type of unfair trade practice going beyond the bounds of an ordinary breach of contract and reaching into the Commonwealth using employees of FTI to maliciously target and destroy a bankruptcy restructuring business that was based in the Boston office. And that's what they did here. Now, if there's no further questions on these two issues, let me turn briefly to the Maryland law.
Yes, on that, assuming we agree with the defendants that the jury instruction was not correct, why is there no prejudice?
There's no prejudice. First of all, it is not correct legally, and I'll come back to that. There's no prejudice for two reasons. One, the jury instruction that they're seeking to strike conformed perfectly with their theory of the case, that FTI was trying to force these guys out. But there's no prejudice for a second reason, which is if there's no deliberate intent requirement, you go to the objective standard of whether the working conditions were so intolerable that a reasonable person would quit. And there's just no evidence of that, or certainly not evidence to overturn a jury verdict on that, where what is being offered is, first of all, the statement that his compensation was reduced $500,000, flat wrong, contrary to the record. The man was paid $2.5 million at a minimum and usually more. The reason he left is he was bargaining for more and they wouldn't give it to him. And under all the case law, when somebody's trying to stay and trying to get a better deal, That is found to be not constructive discharge. Secondly, they stayed during their 90-day notice period. Things weren't so intolerable. They sat there, they worked, they collected the pro rata of their millions of dollars, and they schemed against FTI and sought to destroy it. If we stop 100 people on Tremont Street and say, you can make millions of dollars, and the only problem is you don't like the boss, and you don't feel...
Well, and in that case, then no high net worth person is ever going to be able to prove that, and that seems like an extreme position. So if the response, though, is you ask a different question on Tremont Street and you say your boss cuts your compensation in half, how would you feel about that? You're going to get a different answer.
The compensation was never cut in half.
All right.
Never.
So unfortunately, we did not ask him for a record cite for the $500,000, and you're not going to give us one because you say it's not there. And now I got 9 volumes of a record that does not seem reasonable for us to
There was an
hunt through.
offer of a new form of contract that was more
So what's your record
incentive-oriented.
citation that his compensation wasn't reduced? Like, do you
I'll
have-
try to get that
I don't know
for
how
you.
you prove.
I don't have
that.
that in my notes. I'll try to get it for you. I agree.
Your command of the record has been impressive.
It's a high-class problem, I agree, Your Honor, but certainly there are high-net-worth people who are subjected to intolerable conditions, sexual harassment, abuse.
Well,
I
that's
mean,
a
we've looked at
different-
that for years now as a society. That's not what happened here.
No,
There's just
but I mean,
nothing
taking
like
a law
that at
firm
all.
model is a different way. I mean, some law firms, you get a small draw for many months, and then at some point your compensation starts to look like a hockey stick, but there becomes a question of when that hockey stick occurs. And that, if you had an even draw for a while with some maybe bonus at the end, versus if they said, no, you're getting, and I know many people who work for minimum wage would blanch at this, but if they said, no, your draw is going to be $7,000 a month for 11 months, and then you're going to get one big month of compensation, many high net worth lawyers would chafe at that.
Yeah, I
Say, no, I'm leaving.
I'm familiar with those issues, certainly,
I'm
Your
sure
Honor.
you are.
But the issue here is there was a negotiation. It was never resolved. There was never a change. Duffy was bargaining
So
for
you're
way
saying
more,
his
and he
contract
chose to leave.
never changed?
Correct.
Okay.
The record cite on the compensation is at A3 175 to 77 and A3 316.
All right, thank you.
Unfortunately, I'm out of time. If there's any other questions.
Yeah, he says there was an oral modification that this fellow was going to be the head of the practice group. What do you say to that?
Oral modification requires mutual assent. Nobody, including Mr. Duffy, ever contended that FTI mutually assented to such a change. So there was no modification of the contract. Nobody in the FTI Corporation has a guarantee of an administrative position. The particular position at issue was senior managing director. He was always a senior managing director. He was always paid $2.5 million plus. He always had the benefit of Mr. Coulomb as his assistant. He was always doing bankruptcy restructuring work. That's totally different than the Weissman versus
On the
Connors
length
case.
of the restrictive covenant where it says, it's a year, but if you violate it, then it's extended by the period of time of your violation. Was there any way under this restrictive covenant the period could be more than 2 years? In other words, it says the length of the period is 1 year, right? So I don't know how you could violate it for more than a year.
I think that's right, and I think that's the idea that theoretically, hypothetically, a jury may have applied that differently and had a longer period is just a hypothetical issue here. The judge did what the judge should have done. He read the clause verbatim to the jury, and there was no modification of it. The blue pencil rule doesn't come into effect. The plaintiffs asked the jury for an additional year because that was the year of violation. And like every other jury case I've ever tried, I'm not sure exactly what the jury did, but that's the prerogative of the jury in a democracy, and we don't set that aside on speculative
I
grounds.
think we have it. Thank you.
Thank you, Your Honor.
We will return at 11:25.
Court, all rise.
stand in recess.
Nice job.
Please make sure your cell phones are off or on silent, please. Court, all rise. Court is open. Please be seated.
The next case on our list for hearing this morning is case number 2023 P392, Mary Gattineri versus Williams-Sonoma Stores, Inc., and others.
Good morning, Chief Justice, Justices. May it please the Court, my name is Travis Pregent. I represent the appellant, Mary Gattineri. This appeal arises out of the dismissal of the appellant's claims on the grounds that they were time-barred pursuant to the statute of limitations. The lower court erred in that dismissal for several reasons. Number one, pursuant to the Rule 12b-6 standard, they should have accepted as true all the factual allegations as contained in the first amended complaint. They did not. They also should have drawn all inferences favorable to the appellant. They did not. In fact, on the trial court's order, page 9, they state that a reasonable person, quote, would have discovered or should have discovered that she had been harmed and who had caused the harm when she learned that the pan was being marketed on television. But nowhere in the first amended complaint does it state that the appellant knew at the time she saw that infomercial that she had been harmed. She only suspected. If we look at...
She said, I mean, we have a friend who called her who had said that the product is, your complaint says is the product advertised on TV was virtually identical to her invention, and she watched the commercial.
That's true, but she was unable to confirm at that time and for some time thereafter that it was, in fact, her invention.
On that very day, why couldn't she sue Musgrove?
She didn't know it was Musgrove. It wasn't until March 16, 2018, when her former colleagues at Williams-Sonoma reached out to her and said that it was Musgrove that gave...
Who did she tell besides Musgrove?
She had several executives at Williams-Sonoma view it. I think her brother was the welder who put it together, perhaps some miscellaneous family members. But she was perplexed when it came out. It rose her suspicions, but she did not know. And that's what we make clear throughout the First Amendment complaint. In fact, paragraph 28, First Amendment complaint, the appellant, quote, never stopped investigating how her invention could have been stolen. Paragraph 34 of the First Amendment complaint, the appellant worked to, quote, determine the means by which the apparent misappropriation could be confirmed. Paragraph 59, on or about January 25th, 2019.
But if we were to take that standard, we could never have a dismissal for some statute of limitations, and that's an extreme position that is not going to get you very far. So it can't be just that she made these statements. We have, if the statements indicate that she had enough to file a suit, then she's out on the statute of limitations, as harsh as that is.
I disagree that the statements would indicate that she knew at the time, such that it would trigger the statute of limitations. Again, what I just cited, paragraph 59 on or about January 25th, 2019, Gattineri learned from the firm for the first time the identity of the party or parties responsible. I quote or cite to Mass Eye and Ear Infirmary versus QLT Phototherapeutics, First Circuit case from 2005, quote, the limitations period is told until a plaintiff actually becomes aware of the operative facts, and mere suspicion of fraud is insufficient to end the tolling period.
But even if she didn't know about Focus and Chicago Metallic and Lifetime, right, to Justice Henry's point, she knew she showed it to folks at Williams-Sonoma. File the complaint, discovery goes along, you find these other defendants who potentially have a relation back doctrine. Didn't she sit on her rights with respect to at least Williams-Sonoma?
No, because she did not know that the product that was featured in that infomercial, Justice Blake, was in fact her product.
I thought she saw the infomercial and recognized it to be her product, and that was included within the allegations of the complaint.
It raised her suspicions as to whether or not it's the product, but she did not know definitively.
I think what you're really, I think you're not saying it, but I think what you mean is that somebody could have independently developed the same idea and she just didn't know at that point.
That's true, yes. But there was also other people, perhaps family members, perhaps her brothers. She could have, those people were perhaps precluded, but Yeah, there were other ways by which this could have been invented. It's the perfect brownie pan. It's somewhat generic.
Didn't she need to go to the folks and let's hold Musgrove over here and Williams-Sonoma to the side, but she needed to go to her brother or other family members and say, did you share my idea? And they all say no. Now that was all within her capability. Now she goes to Musgrove, and Musgrove either stonewalls or denies, and then why can't she sue Musgrove?
Well, Justice Henry, you brought up a good point before, and that is that it could have been independently developed, and she was unaware as to whether or not it was truly an infringement on her product or whether somebody just happened.
But she has information and belief that would justify making factual allegations in the complaint, and then you've determined that other information through discovery.
Yeah, but to just file a complaint against a party for whom you're not sure whether or not they're the actual wrongdoer can lead to sanctions or attorney's fees.
It had the same name. I have a question. Does perfect modify brownie or pan?
Pan.
Okay.
Perfect brownie pan.
And you haven't brought samples? No. Okay. What about the patent?
So, as we stated in our appeal briefs, a patent puts out notice, constructive notice to the world of its existence, but it does not necessarily put out notice or inquiry notice to plaintiffs. I think we cited this in our brief. We have a claim, not a patent. You know, if you look at Katz v. Avenar Pharmaceuticals, Southern District of California case, they state whether, quote, whether issuance of a patent provides sufficient notice of the existence of a claim is a separate issue. Issuance of a patent standing alone does not put the claimant on inquiry or constructive notice.
Oh, but I hear those words.
Yep.
But in this context, if it places the world on constructive notice of the patent for the product described in the patent, isn't that indistinguishable?
I don't see it as...
Because she knows what her pan was.
Not where there's fraudulent concealment, Your Honor, and that's what we're alleging here. Is that
what does constructive notice mean then? If she's on constructive notice of the product that is the subject of the patent, then there's nothing left to conceal.
Well, there is something left to concede, whether or not the patented product was substantially similar to her product so as to put on inquiry notice.
The patent describes all of the attributes of the product that is protected.
Right.
She knows what her product was. She can conduct that comparison. There's nothing left to the imagination at that point. Now, I suppose, in theory, there's a question about who it was that she should sue, but then we're back to Judge Henry's point about she knows who she showed it to. She can name them and then through discovery find out whomever else is involved.
Again, I would disagree that that would be the right course of events.
We can
because
disagree.
She wasn't sure that that was, in fact, her invention. And I think if we're talking
at some level of sophistication, right? I mean, she did, before she even showed it to Musgrove, she was operating a DBA and had her sign an NDA. Pretty unusual for a self-represented individual. So she knew she had something. She sees it on TV, thinks it might be hers. Maybe it is, maybe it isn't. But then waits till 2021. So that's how many years later? 18 years later.
Well, she didn't wait till 2021. She went out.
Filed her complaint.
I understand, but she went out and she tried to recruit lawyers to bring her claim at that time.
That's correct. So
that is about as strong an indication that she had knowledge that she had a cause of action.
But nowhere in the First Amendment complaint is that stated. I suppose you can impute that based on the facts as alleged, but it's not stated there. And pursuant to the Rule 12b-6 standard, I don't think that you should be incorporating new facts into a complaint.
But it seemed like you were saying that by March 2018, she did have knowledge, enough knowledge to bring suit. Is that?
March 16th, 2018. That's correct.
Right. But she didn't end up bringing suit until after that in 2021, right?
So the earliest date mentioned in the First Amendment complaint for when she could have possibly been put on inquiry notice such that it would trigger the statute of limitations is March 16th, 2018. 3 years and 106 days from that date is June 30th, 2021. The complaint was brought June 24th, 2020.
Right, so anything with a 3-year statute of limitations, you would agree is out?
No, it was brought within the 3 years and 106 days pursuant to the COVID rules.
It was brought within 3 years and 106 days?
Yes.
But some of the causes of action have a 3-year statute, don't they?
But with the COVID
Oh, with
106-day
COVID,
extension.
thank you,
yeah.
okay. So in
So
the,
all of her claims are within the 3-year statutory limitations if we go by the First Amendment complaint. And by the way, March 16th, 2018 only applies to Williams-Sonoma and Appellee
Right,
Musgrove.
okay, but
that
so-
would be the earliest triggerable date.
but looking at the judge's order, and I'm looking at page 46 of your brief where you have the order, in the second full paragraph, you're not challenging the judge's recitation of the undisputed facts where the judge says that she knew she'd disclosed the pan to Musgrove, and she knew the pan was being marketed by All-Star. You agree with those. And she knew Focus, this is all in 2009, she knew Focus was behind the product marketed by All-Star, right? All of that you agree with.
I'm sorry, I don't know that I agree with that. Is it stated there that I agree with it?
No, I'm asking you.
Okay.
Is there?
No, so I would say she absolutely did not know.
Well,
She
she
did not
knew
know that
she
that
just-
was based on her product.
Well, she knew she had disclosed the pan to Musgrove, that she knew that by 2009, and she knew what All-Star was marketing a pan that at least a friend of hers thought was virtually identical to her invention, right?
Yep. She also knew that she had disclosed the pan to other people. She also wasn't even sure how, if she had disclosed the pan to somebody at Williams-Sonoma, it would end up through the stream of commerce going outside of that company. I mean, it's a fairly complex and opaque series of events that happened as described in the First Amendment complaint. She has her invention, the prototype perfect brownie pan, secreted away by the appellee Musgrove, who gives it to a representative of Chicago Metallic. Chicago Metallic is then purchased by Focus. Later on, Focus's subsidiary, I think it's FPG LLC, patents this infringing product. Between this and the appellee's fraudulent concealment of their actions, I think it's fair to say that the appellant was not on inquiry notice until, again, March 16, 2018 at the earliest.
But at 232 and 233 of the record, which are paragraphs 26 and 27 of the First Amendment complaint, specific to what Chief Justice Green asked you, it says that from '09 continuing through 2012, your client met with 4 different attorneys and that they advised her she didn't have a viable claim. So why isn't, to re-ask the question, why isn't she on at least inquiry notice then?
Well, the second part of that paragraph says that she does not have a viable claim because she did not obtain a patent.
Could not prove how or why or by whom the invention had been stolen.
So and that goes to legal advice, not to her, as Judge Blake describes, inquiry notice. She knew enough that her product was being infringed. She may have gotten bad advice. But that's a different cause of action.
Yeah, I don't know. I think there's some subjectivity, Chief Justice, in determining whether or not she knew enough. I would argue that she did not.
But the point is, just going back, that I went back and looked at the trial judge's motion after you responded to my question. I'm sorry, the trial judge's memo. The trial judge didn't just invent those facts. He didn't go outside of the 4 corners of the complaint. He drew that information directly from the complaint.
Well, the language of the trial court's order, I think, confirms that there's a question of fact as to whether the appellant was put on notice of her claims, as well as to whether the appellees fraudulently concealed their actions. You look at page 9 of the order. They stated, quote, even if the information known to the plaintiff in 2009 was not enough to start the running of the limitations period, the issuance of a patent on the pan in 2010 surely did. Again, I believe that the issuance of a patent on the pan did not, but that the theoretical even if that the trial judge uses clearly suggests that a question of fact exists, such that on a motion to dismiss.
All right, so what are the affirmative acts of concealment that you are alleging in the First Amendment complaint?
Well, appellee Musgrove took possession, custody of the perfect brownie pan without the appellant's knowledge or consent. She showed it to Chicago Metallic representatives who then took it upon their own to patent this product by way of Focus Products. Also, we've discussed Lifetime's role in this. The appellee, Warren Tuttle, was the lead person responsible for their inventions. He knew the appellant throughout all these years. He was aware of her claims regarding the perfect brownie pan.
But what did he do to her that was an affirmative act of concealment?
He pretended as if he wasn't aware that they were, in fact, in possession of the perfect brownie pan, that they were selling the perfect brownie pan.
All right, so the motion judge wrote that the only allegation of an affirmative act of concealment appears in paragraphs 49 to 51 of the first amended complaint and did not occur until 2018. Is that, I take it you disagree with that?
I disagree with that.
Okay.
Yes. I might also add, I'm running out of
Well,
time.
I think you can rest on your brief for anything else. We have it.
Okay.
Thank you.
Thank you.
Good morning, Your Honors. My name is Matthew Labrie. I represent Williams-Sonoma Stores and Ms. Teresa Musgrove in this matter. I will begin, and then I'll hand off after 7.5 minutes to counsel for Lifetime. There's a few points I want to make right from the outset. First, page 14 of appellant's brief admits that in 2009, she was on inquiry notice when she saw...
Let's pause you for a moment, because the problem you have is that two different people can independently invent something having nobody doing anything nefarious, just they both have the same idea at the same time. And so she sees this pan, so let's just make this a little different. Let's say she pitches to Williams-Sonoma, and then she sees on the internet or on the cable TV show that Williams-Sonoma's arch competitor, I don't know who that would be, but their arch rival, that somebody they would never share information with, is marketing the pan. Is the statute of limitations running at that point?
I would say yes, Your Honor.
Why?
Well, I think it's important to recognize that this is a very different case from that. In the complaint, Exhibit K to the complaint is plaintiff's letter from her attorneys at Steptoe that about 5 or 6 different times explicitly say that plaintiff was the inventor of the pan, that plaintiff was entitled to all royalties and other profits from the pan, that the pan was infringing upon plaintiff's invention. There is no question based on the facts pled by plaintiff that she understood it to be the exact same pan, and that's what's key.
Yeah, but you can have two people invent the exact same invention independently without any nefarious activity. Sorry, patent litigation background here. That is like fundamentally through history. In fact, with every major invention, you often have two people independently inventing because everybody knows what the cutting edge issues are, and they're racing to the clock, from the radio to how we diagnose HIV. Grant you, brownie pans may not be on the cutting edge of science in that way, but for anyone who has children, brownie pans are very important too.
I would agree that brownie
Even
pans
the
are
children
important.
among us, the adult child among us. But so inherently, she doesn't have to know by seeing that commercial that someone stole her idea.
But what I think Your Honors hit on earlier is the fact that plaintiff knew she only had disclosed her pan to Musgrove. And if you look at plaintiff's,
Maybe some family members, but okay.
Correct, and family members. But in appellant's brief, she explicitly said that she did not show it to anyone else at Williams-Sonoma. So Your Honors were correct, that when she saw the pan, when she believed it to be the exact same pan, she knew who she had disclosed it to. She knew she had disclosed it to
Right,
Musgrove.
but he's saying if she had just sued Musgrove, or maybe Musgrove and Williams-Sonoma, but let's just stick with Musgrove, and the chief indicated maybe she says on information and belief Musgrove disclosed. Would that have survived Rule 11, or would she have faced sanctions? Or maybe she should have done that, and then that would have helped her statute of limitations case.
She should have done that, and that would have helped her statute of limitations case. Eli Lilly, the Bowen versus Eli Lilly case makes very plain that the standard for a statute of limitations decision cannot be knowledge of actual causation. You'd only get there then after the trial. And so Your Honors were correct in saying that She should have brought the case in 2009 when she had actual knowledge that she had been harmed, or a reasonable belief. And that's where we are. We're at a reasonable belief. We're not at actual knowledge. When she had a reasonable belief she had been harmed and had a reasonable understanding of by whom. And I would like to set aside for the moment the idea that she actually knew at the time, as the trial court found, and focus on the fact that this is an objective standard. An objective person, a reasonable person in appellant's position would or should have known in 2009 that she had been harmed and by whom. And there is a lot of discussion, about the investigation that was ongoing, but the point remains that appellant concedes that in 2009 when she saw the ad that she was on inquiry notice. They concede that. And so then the question...
Investigation is a form of inquiry, isn't it?
It is a form of inquiry, you're right, but the question then becomes, is it a reasonable investigation? And what appellant did not do at any time between seeing the advertisement and filing this lawsuit 12 years later is talk to Musgrove. She does not plead she did that. She does not plead she talked to any...
That was not for want of effort.
There is no allegation in the complaint that she made any effort to talk to Ms. Musgrove or anyone at Williams-Sonoma.
Well, so I'm still trying to test the outer boundary of your argument, because we do like to do that. So if she disclosed to Pepsi and then she sees Coke is marketing it, does that inherently mean she knows she's on inquiry notice that she was harmed?
I would submit that yes, it does. I would submit that that would be a very different case, and that would be a much closer case. We are not dealing with a close case. We are not dealing with one fact that might go either way that should go to a jury. We are dealing with a plethora of facts and legal admissions by appellant that put us squarely into on inquiry notice actually and objectively. I would also like to point out that with respect to the allegations of fraudulent concealment, there is no allegation of any act whatsoever conducted by Ms. Musgrove or Williams-Sonoma that was fraudulent in any way. Primarily,
what if instead of fraudulent concealment, it was just stonewalling, right? Because if you look at, she says that once she saw the commercial, and the judge quotes, she was concerned that confidential information relating to her invention had been disclosed without her authorization and others were wrongfully profiting from her idea. And then he says her efforts to contact and obtain information from All-Star were unsuccessful. All-Star just puts up a brick wall. It just won't respond. What is she supposed to do then?
well, I'll let my co-counsel here discuss All-Star, but she did not.
Same thing with Williams. If
Exactly.
she just hits a brick wall.
But she didn't reach out to Williams-Sonoma or Musgrove, and what's important here is that for fraudulent concealment claim, there must be some affirmative act by Williams-Sonoma or Musgrove that results in the fraudulent concealment. There is no allegation in the entire complaint that there was any act by Williams-Sonoma or Musgrove. There's no communication between Williams-Sonoma and Musgrove and appellant. And without that communication...
Counts against Sonoma and Musgrove were breach of the NDA, fraud, misappropriation, conversion, negligent... So everything except there were two additional ones, which was breach of the non-disclosure and fraud?
Correct.
Okay.
But, and Your Honor, you point out a good point that there are thin allegations of fraudulent concealment against other defendants, but no allegations of any act whatsoever by Musgrove or Williams-Sonoma. My time has expired unless you have further questions.
Good morning, Chief Justice, Justices. My name is Chris Queenan, and I represent the defendant, Appellee Lifetime Brands, Inc. With respect to my client, Your Honors, plaintiff has placed herself in a catch-22. If she's plausibly alleged a trade secret misappropriation claim against us, then her claims are necessarily time-barred, and here's why. She alleges that Lifetime acquired the pan indirectly through a third party who is not a party to this action, Focus Products Group. That means in addition to the normal elements of a trade secret claim, misappropriation claim, she also has to allege that we knew at the time we were obtaining a trade secret and that we knew at the time that who we were obtaining the trade secret from had a duty not to disclose it to us. I think in other words, she has to prove that we weren't, or allege that we weren't a bona fide purchaser of this pan. And
Well, do you have anything to add to what we heard earlier about Judge Henry's question about parallel development?
yes, I think it absolutely puts her on inquiry notice, and here's why. Because one of the elements of a trade secret claim is that you took reasonable precautions to protect that trade secret. Trade secret law is harsh, admittedly. When you see your product of the same name out there being advertised, big box stores, infomercials, magazines in 2009, a light should go off in your head and think, my secret must have gotten out there. And you have a duty to go out there and investigate that. And if you go out there and investigate that and realize this was independently developed, this is a bona fide purchaser or someone who developed this on their own, end of inquiry. That's what you do. That's your investigation. So yes, it is harsh, but that's why it is harsh.
You reached out to your client.
Yes, so
Got no response.
what happened, she reached out to Focus Products Group from 2009 to 2012, who is not my client. They're not named here, which is...
What's the relationship between Focus, All-Star, and Lifetime?
We acquired, as she alleges in the complaint, in 2016, we acquired the patent to the pan.
But not the company.
Not the company. We acquired a division of Focus Products Group. And this isn't new facts that I'm adding. She attaches a letter from her attorneys in 2018, Exhibit M, which sets this forth. They reference publicly available documents, our 2016 annual report that reports on our acquisition of the Chicago Metallic brand and the intellectual property, a Wall Street Journal article that says the year prior, we, a public company, obtained Chicago Metallic brand. Her attorneys are saying in these letters, this is out there in the public in 2016. And that goes to a key point here. We didn't acquire a trade secret. We acquired a patent. We can sit here and debate what it means and whether the issuance of a patent starts the statute of limitations period in all circumstances. We don't even need to do that here because there's a lot of other things that happen that shows she was on inquiry notice, but let's set that aside. There's no debate that the issuance of a patent destroys the trade secret. There was nothing for us to...
Let me ask you then about what starts on page 10 of Judge Krupp's decision at footnote 11. He sort of goes through, I think, what you're talking with us about now, the fraudulent concealment. He says there could be no fraudulent concealment because there was no detrimental reliance, and she doesn't allege that any of the defendants owed her a fiduciary duty. Do we have to get to that point to affirm, or is it because we're looking at just what's alleged in the first amended complaint, and we're looking at the gap between the 8 years when the patent issued and then ultimately, I guess, filing suit? Does our analysis stop there, or do we have to go further?
For us, you don't have to go any further. She alleges that she first talked to my client in 2011. And as of 2011, the patent had issued. Okay. There could be no concealment at that point. And in fact...
That's not correct. Obviously, the knowledge of the patent is there, but she doesn't know who invented it or didn't invent it or who stole it. So if you found out 10 years later that, in fact, they did steal it from you, and it was concealed from you all that time, then you could bring a suit.
Well, not against us, because that would mean we were a bona fide purchaser. And this is why she's in a catch-22 with respect to us. Because to allege a misappropriation claim against us, she has to prove at the time that we knew that Focus Products Group, who's not a defendant here, had a duty not to disclose to us. And to get around that, we moved to dismiss the original complaint on that ground because there were no facts. Then she added these facts about Tuttle and what she told him, and this is what she had to do. She had to say, hey, Lifetime, before you acquired this patent, I told you about my claims. She alleges that in the complaint, that she was the one who informed us about her claims. So she's in a catch-22. That had to be before 2016, which is 5 years before she filed the lawsuit. And that's why the claims fail against us, under any reading of the facts or any discussion of these
Did she say
questions.
when it was that she disclosed this to you?
It had to be before 2016, and here's why. She says that she's first talked to Tuttle, the front end is 2011. Paragraph 42, she first talked to Lifetime and Tuttle in 2011. In the back end has to be before we obtain the PAN, which is paragraph 47. She says, at the time Lifetime licensed and acquired Focus's products, including the Perfect Brownie Pan, it knew or should have known it was acquiring Gattineri's misappropriated trade secret because, as set forth above, and it references those discussions in 2011, Tuttle, Lifetime's agent and employee, was responsible for sourcing Lifetime's new products and was fully aware of Gattineri's inventions and claims. I mean, she says it right there. She told us about our claims before 2016.
Do we have to reach your personal jurisdiction argument if we agree with you on statute of limitations?
No, we're seeking to affirm on the court's decision below, which was that it was barred by the statute of limitations.
So what's the relationship between Focus and Chicago Metallic Brand? Let me back up. Is Chicago Metallic Brand just a brand or is it a company?
Your Honor, all I know is that my client acquired the Chicago Metallic Brand from Focus Products Group in 2016 after the patent was issued in 2010.
You don't know if that's a brand or if it's some sort of company, but
I don't know. I don't know,
whatever it
Your
is, your client acquired it.
I don't know, Your Honor.
Okay.
Unless anyone has any other questions, I'd rest on my briefs on the remaining issues.
Seeing none, thank you both for your arguments.
Thank you, Your Honor.
Thank you all for your arguments. That brings us to the fifth and final case on our list for hearing this morning, case number 2023 P220, Greater Lowell Technical High School School Committee versus Greater Lowell Regional Teachers Association.
Good morning. Good afternoon. Chief Justice, Justice Henry, Justice Blake. My name is John Becker. I represent the union in this matter. May it please the court. I represent the Greater Lowell Regional Teachers Association. This case involves the employer's attempt to avoid arbitration of a grievance filed by the union alleging that the employer failed to follow its own procedures for filling a vacancy at the school. The Superior Court granted...
Can I stop you for a
yes.
minute, Mr. Becker? Let me figure out how to ask you this. You agree that the appointment decision itself is non-arbitrable, but that you contest the process by which Mr. Jones was non-selected?
That's correct, Your Honor. Yes.
And one of the things that Mr. Jones was upset about was that there was a woman on the interview panel who had witnessed the incident that led to the letter of reprimand.
That's one of the things that's, yes, alleged in the grievance.
So one of the things I take from your brief is that somehow the letter of reprimand was improperly used in this process. But I want to ask you, I saw nothing in the MOA that spoke to whether it could be used or not. But perhaps more importantly, the letter of reprimand was going to be removed, as I understand it, on March 31st of 2019 if there were no prior incidents. But the interviews took place in February of 2018. So wasn't it free game for them to look in his personnel record? The letter, by terms of their own agreement, was not removable at that point. So why is that a problem?
Your Honor, I think that the questions that you're asking right now are questions that would be presented to the arbitrator if this goes forward to arbitration. I think those go to the merits of the case. They don't go to the issue of arbitrability. I think the issue of arbitrability is, did the union allege, and we just heard a motion to dismiss case. It's sort of similar to a motion to dismiss. Did the union allege that there were violations of procedures that were in the contract? Yes, they did. Since they've alleged violations of procedures, that should go to arbitration. And then the arbitrator
What section
can...
of the CBA do you say they violated, right? Because you have, I think it's Article 2, Section 7, maybe, that defines what a grievance is?
Yes, the definition of grievance is very, very broad. And if you look at, for
It is,
example...
and we have cases that talk about when it's broad, that you should
Yeah.
think that that's arbitrable. But
And
we do have the whole issue that by statute, the appointment of a coach is within the purview of the superintendent. And even the cases that say broad language, when there is, in fact, statutory authority to the contrary, the statute controls. So why isn't that the case here? 47A, right?
Well, two things about 47A. One, which, just to point out, it talks about hiring a coach. It doesn't talk about appointing a coach.
What's the difference?
There are many school districts that hire coaches as employees where that's their only job. And in this case...
He's the plumbing teacher
he's a teacher,
by hire.
and he's already covered under the...
Did the coach, softball
He was
coach.
appointed a coach, and the appointment of the filling of any vacancy inside the department, inside the school, is governed by Article 10, Section D, which says all vacancies shall be filled on the basis of the experience, competency, qualifications of the applicant, length of service in the school system, and other relevant criteria. And that's the position we feel establishes a procedure. It says all vacancies, there's no exclusion, and this is certainly a vacancy. The varsity softball coach position is a vacancy, and there's nothing that excludes that. So we think that provision that creates a procedure, there's nothing in the coach's statute or the collective bargaining agreement that excludes procedural grievances even over appointments that are where the ultimate decision is a management right.
So let's get to the ultimate question, right, that the Superior Court judge said it's a distinction without a difference, and I know that she cited a case that's now a legal nullity here because the SJC, although they still affirmed, they did it on different grounds. Putting aside that case, what is the difference?
Your Honor, there's a big difference. First of all, what normally happens in these cases, and if you look at the tenure cases, for example, you'll see that what happens is the arbitrator hears the case. If they decide that the procedures were violated, and that's a big if. We don't know what's going to happen when we go to arbitration. But if the arbitrator decides that the procedures were violated, then they basically have a do-over. They have to go back and they have to do it over, and this time they have to do it right.
Why is this a procedure as opposed to a substantive element that was a factor in their ultimate decision?
Well, I think there's a difference here because this is, they say specifically we're only going to use relevant criteria. And our position is that using this incident that they settled with the individual, that the superintendent specifically said to him, we're not going to use this against you. And then they say in their MCAD filing, that's exactly why we decided not to reappoint
Where
him.
does it say in the MOA that it's not going to be used against him?
It doesn't say it in the MOA. It was said in a conversation, in a meeting that was held between the union, the individual grievant, and the superintendent.
There's a difference, it seems to me,
and that's alleged
on the substance between saying we're not going to use the reprimand and we're not going to consider the incident that underlies the reprimand.
Well, Your Honor, to borrow the Superior Court's language, I think that's a distinction without a difference.
Well, no, it's not really, because they pulled the reprimand from the file, but the fact that led to the reprimand, maybe there's a disagreement about whether that fact warranted a reprimand, but there isn't necessarily an agreement that the fact didn't occur.
Well, we're not saying there's an agreement that it didn't occur. What we're saying is...
maybe in the view of the superintendent, that was a consideration that was relevant.
Well, Your Honor, our position is that it was, first of all, that goes back to the arbitrator. The arbitrator could find exactly what you said.
No, of course, if it were arbitrable. But I go back to my question about what is it that makes that a procedure? As you know, you can say that the agreement says we will convene a panel, we will solicit input from X, Y, Z, and Q. But this is a consideration of a factual question bearing, in the view of the superintendent, on the suitability of this person for appointment.
Your Honor, I think that the union and the employer negotiated this provision, Articles 10, Section D, into the agreement for a reason. It's not, they're saying, here are the criteria you have to look at. And listing the criteria that you have to look at is, in our view, a procedure. I don't
But let's
know.
look at the Roxbury Community College case, the SJC version of that, right? At 798, the SJC says, just because the parties framed the dispute as concerned with the manner in which the union member was denied tenure does not change the fact that at bottom, the denial of the tenure was the issue. Why doesn't that apply with equal force to the situation here with the softball coach?
A couple of reasons, Your Honor. First of all, the language in that case, that the MCCC case, is very different than the language in our case. And I'll show you why. First of all, it's the language that they're citing to is right in the grievance procedure. So it goes right to the issue of arbitrability. And it says in the grievance procedure in MCCC, the granting or failure to grant tenure shall be arbitrable, but any award is not binding. So that's the language that Justice Botsford was interpreting in that case. In our case, this is Article 3, Section L, and I think it's important to read it in its entirety to see the context. No teacher will be disciplined, reprimanded, reduced in rank or compensation, not reappointed, or deprived of any professional advantage without just cause. So it's about discipline. This is not to be construed to mean that appointments held on a year-to-year basis, such as class advisors, coaches, non-professional teachers, non-professional status teachers, etc., cannot be changed by administrative recommendation. Changes in these assignments are properly an administrative function or responsibility, and changes do not imply disciplinary action. That is a much more constricted and restricted right that is being given.
Finished out the coaching season during the incident, the year of the incident, right? He finished out that coaching season.
That's correct, Your Honor.
So
He was not reappointed to the next season.
doesn't the CBA say, though, that the selection process for the coach is an administrative function, and therefore that makes it non-arbitrable?
It doesn't say the the selection process, Your Honor, and that is the key.
Help me with the
It says that
What section are you relying on?
Article 3, Section L. It says this is that appointments cannot be changed by administrative recognition, changes in the assignments. So the changes in the assignments or the non-reappointment is the decision, and this goes back to the statute, the difference why the statute doesn't apply here, and why this is separate from the decision to say this person is going to be the coach or this person is not going to be the coach. But what they look at, what they're going to be going through, what kinds of criteria they're going to use, those are procedural issues that are arbitrable and have been negotiated, and the negotiation is intended to mean something. And the presumption of arbitrability, which the Superior Court...
We're focusing on discipline, but if you finish reading L, because like you said, we should look at it in its entirety, and I read the part about changes being an administrative function, it does note that changes in these types of assignments are properly administrative and do not imply disciplinary action. So if the disciplinary action requires just cause, the next sentence says a change in the appointment of coaches is not a disciplinary action.
That's exactly right, Your Honor, and that's why we didn't file a grievance for that the non-reappointment wasn't for just cause, because we knew we didn't have that grievance. The only grievance we had was the grievance to say you didn't follow the proper procedures, because there's nothing in here about procedures.
Shorthand for us, what were they supposed to do that they didn't do?
They weren't supposed to take this underlying incident that was the subject of the written reprimand into account when making the decision.
That's not a procedure. That is a
They used
criteria.
irrelevant criteria, Your Honor, and that violated the procedures
Not
that
an
were
irrelevant criterion because it goes to his conduct, which goes to his suitability.
But it became irrelevant when the parties decided to take that out of the equation.
To take the reprimand out, not to take the conduct out.
But, Your Honor, I don't see what is the point of taking out the reprimand if you can still use the underlying conduct against him? In other words, the written reprimand is normally what you can only use against somebody, obviously this is in the record, but you're normally using somebody's prior disciplinary record against them. And so instead of using their prior, they're playing games, basically saying, well, we're not using the prior disciplinary record, we're just using the actions that led to the prior discipline. It's not what the parties intended.
So you say on page 18 of your brief that the MOA resolving the letter of reprimand issued to Mr. Jones prohibited the committee from considering the underlying incident. What language in the MOA are you relying on? I see the MOA at
71, 72.
Yes.
Well, it was the main language is that it would be removed from his file, and I know that I know that the town or the school district says that it wasn't supposed to be removed from his file until after the appointment, but that is a question of fact I think the arbitrator has to resolve. So our position would be if it's out of your file,
right, okay.
then you don't consider it, and you don't consider, and I have to respectfully disagree with the Chief Justice, you don't consider the underlying
Can you consider
facts.
the letter of apology that he wrote to the athletic director that's set forth in the MOA? That's not going to be removed, but that's on page 71. Jones.
Well, under the Personnel Records Act, something that's attached to a piece of discipline is normally stays with it. So I would assume that it would be taken out when the
Well, so looking at the MOA on page 72, paragraph 3, there's a sentence that, to be honest, I have no idea what it means. It says, each party, I get that, agrees the underlying claims are disputed and that this matter is resolved without prejudice to another party's position on the merits, and that, this is the part I don't get, and that such agreement shall not become or be challenged or asserted as to past practice in any subsequent proceeding. What does that mean?
It basically means that the union can't use this decision, this removal of this thing to say that the school committee has now established a past practice of not disciplining people for doing things like this.
Okay, and on this issue of procedure versus substance, so if the superintendent says, I'm going to have 4 people make this decision and they have to be unanimous, is that something you could challenge as arbitrable? Is that process that you think you could challenge?
If it's something that was agreed to by the parties and is in the collective bargaining agreement, yes.
What I'm asking.
Or actually, under this broad definition of grievance, that would be covered because it says any violation of any committee policy, school committee policy or practice, or an expression of dissatisfaction with any aspect of a teacher's employment or working conditions. So I think that would be, if that were established as an official rule for the, and we believed that there was something that they didn't follow that it wasn't unanimous, for example, I think that we would have a procedural grievance as well.
If the superintendent said, we're giving priority to somebody who played this sport in college, is that something you can challenge as part of the process?
if he said that and then didn't follow it.
Okay, he can say it, or
Sure.
they can say it.
They can say it whatever they want, but they have to establish I guess unless it goes beyond the point of relevant criteria, then we could say, well, this isn't relevant if they're saying it's because, you've been to Christmas parties at the superintendent's house, you're going to get preference. Then we would say, well, that's not relevant criteria.
Okay.
Just like we say that using the underlying incident that was supposed to be taken out with the reprimand is also using irrelevant criteria. I have no further.
Thank you.
Thank you. I'll rest on my brief. Thank you.
Good afternoon, Your Honors, and may it please the Court. Madison Harris Parks for the Plaintiff Appellee Greater Lowell Technical High School School Committee. I will start by saying that the union's request to arbitrate the appointment of a coach is appropriately stated as it is a non-delegable duty of the superintendent pursuant to statute. Additionally, there is nothing in the agreement setting forth that the parties have agreed to arbitrate a dispute regarding the hiring process, specifically
What
this.
if they said, we're going to have 4 people make a recommendation to the superintendent, their recommendation needs to be unanimous, and then it turns out they send up a 3-1 decision? Can they grieve that?
It needs to be very specifically expressly stated that the school committee has agreed to this procedure or this process behind this otherwise non-delegable duty, and agreed that that is arbitrable. So looking at the language of the contract and what is being considered here, we see no process agreed to that is being specifically argued by the union that was violated. Nothing in the contract saying that the school committee agreed to a specific process when making this decision. It goes to, what was considered remains with the superintendent, what to consider when making this appointment.
Well, he's basically saying, I think, that you had a contract or some sort of agreement, and that, there's you a duty of good faith and fair dealing that you said this letter was going to go away if he behaved, and that you violated that. And that falls under 2A of the collective bargaining agreement. It's a broad definition of what's a grievance. What do you say to that?
It is a broad definition of a grievance, but even a broad definition of a grievance can't give the arbitrator power over disputes that are barred by statute or agreement. So we know that the actual selection decision is barred by statute, and so the requested relief here to have Mr. Jones reappointed or appointed into that position is something that the arbitrator cannot by statute do. And then in terms of...
Well, but he's saying, I'm not asking you to order him appointed, nunc pro tunc or in hindsight. He's saying, do it over and follow the right rules.
I guess I would say what are the right rules? Because there are no
Don't
specific...
consider this letter that we took out of the guy's file.
I don't see anywhere, I guess, in the contract that says don't consider this letter. I mean, even if you look, as you said, looking at the exact language of the memo of agreement, it doesn't say that it can't be considered. And then, even then, this memo of agreement, this understanding that was entered into, was a settlement for the parties based on the grievance that the union brought related to the reprimand. I think a more appropriate form of relief here would be some sort of unfair labor practice if what they're arguing is that there was some sort of good faith issue here in resolving that matter. Versus, in order to compromise the statutory authority that the school committee has and that the superintendent has over making this decision, which can include the process and the substance unless there is a very specific process and procedure that they have agreed through bargaining to follow and to adhere to. And there is just no process and agreed to procedure specifically for the hiring of coaches.
Well, so in their brief, though, I don't think they mentioned it today in argument, but they refer to Article 10, paragraph D, which says all vacancies shall be filled on the basis of experience, competency, qualifications of the applicant, length of service in the school system, and other relevant criteria. So just to take something absurd, if the superintendent said, okay, we're giving first priority to somebody who can knit and clear 7 feet on the high jump to coach girls softball, would that be arbitrable as not relevant criteria?
Well, first, I would say that Article 10 isn't applicable to these yearly appointments, including athletic coaches. It speaks to vacancies and promotions, but the coaches, as well as other yearly positions, are appointed. It's not read as a vacancy that needs to be filled, or certainly not related to a promotion that's being given to someone. There is a separate, I think it's Appendix C of the CBA that lays out the separate salary and talks about this appointment as an assignment for whoever was selected to hold the coaching position.
So you're saying if the superintendent announced some wholly irrelevant criteria, there's nothing that the union can do?
I think if they, within the CBA, bargained and agreed or created an agreement between the union and the school committee.
No, but under this CBA, you're saying there's no ability to arbitrate that?
I agree. Or yes, that is what I'm saying, because I am saying that the vacancy, Article 10, speaks specifically to vacancies and promotions, which does not cover the year-to-year assignments, which include coaching positions.
What provision does cover the year-to-year assignment of coaching positions?
So it speaks specifically, Article 3, Section L speaks to these positions, these year-to-year positions, and says in no uncertain terms that it is a administrative function, and that so it says changes in these assignments are properly an administrative function and responsibility. And so there can be no defined process there for the appointment of athletic coaches when the appointments are subject to change and subject to administrative responsibility, looking at whether or not they're even going to have that position the following year, depending on resources and the number of students interested, factors such as that. It remains wholly with the school committee and with the superintendent for making those appointments and those decisions, which then, as this statutory and non-delegable right, cannot then be abrogated by agreement unless there is something specific to the process leading to that appointment. The Natick, the School Committee of Natick case, which speaks to and interprets the General Law, Chapter 71, Section 47A, and says that this appointment decision is non-delegable and cannot be abrogated by agreement, and mentions it's factually similar there. The coach was not, or was displeased by the superintendent not renewing him for the position the following year based on just a bad record of, or parents being unhappy with the fact that they hadn't won in recent years when he was coach. And so in that case, the SJC said that it was not arbitrable and mentioned that if the union had pointed to a specific procedure that had been violated, then that could be arbitrable. And so in that case, they have in a footnote the exact procedure that was laid out for athletic coaches, how athletic coaches would be appointed pursuant to that CBA. So that was a very specific process that the school had agreed to that could be arbitrated if they failed to follow that process, which just is not is not here within this CBA, looking at the contract as a whole and the intent of the parties, this explicit language speaking specifically to coaches and other year-to-year appointments, and maintaining that that stays within the administrative's responsibility.
So, but paragraph L ends with if it is determined that action has been taken against a teacher in violation of this agreement, the teacher shall be restored to no less than the position and circumstances which existed prior to the action having been taken. So if he's right, and I get that you disagree, but if he were right that there was a memorandum of understanding that expressly said, we will not use this incident against you in making a coaching decision, and then they did, is that arbitrable?
I think it could be. I think that there would need to be, again, just looking at the facts of the memo of understanding, who it was between and whether it goes into the CBA and this agreed upon process related to the decision. So yes, if it specifically says pursuant to any interviews that will be held for this specific decision, if there are issues with the process or an agreement or specific promises made about an agreed to procedure. Whereas here, again, there has not been a specific agreement as to the procedure for hiring athletic coaches specifically, something that needs to be present in order to overcome the inherently non-arbitrable decision. As the courts have found, it's just arguing that the manner in which a decision was made is the same as arguing against the decision itself. So if the court doesn't have any further questions.
Seeing none?
I'll rest on my brief.
Thank you.
Thank you.
That concludes the argument. Excuse me. Concludes the argument in this case. We are adjourned. We will come back out to meet with the BU students, and we'll answer your questions as soon as I clear my cough. Thank you.
Court is now in recess.